Okay, so we now have a quorum and we'll begin the COPRAC meeting. And this meeting is being recorded. And with the permission of the chair, I will start with the roll call.
Yes, please do.
Dina Roach.
Here.
Ken Bacon.
Here.
Sarah Bonola. Steve Bundy.
I'm not I guess I should say here. Go ahead.
Hey,
yeah,
Andrew, sorry to interrupt
Please.
you, but I noticed that Sarah's on the attendees. She's not into the panel, so she may not
Oh,
be able
yeah.
to be heard, or I just want to make sure. And Hunter looks like he's also in that attendees location.
Sure, let me elevate them. Thank you.
Who's that guy that says David Carr? He looks different. No beard?
Yes.
Took me a second to figure out what was different.
Okay, I believe both Sarah and Hunter have been elevated. So let me resume the roll call.
Thank
After
you.
Ken Bacon said he was here, Sarah Bonola,
Here.
Steve Bundy,
Here.
David Carr,
Present without beard.
Justin Fields,
Here.
Toby Inlander,
Here.
Adam Koss,
Here. Sorry.
no problem. Brandon Krieger,
Here.
Amber Lee. Amber is not able to join us today, just for the information of the rest of you. Joel Mark.
He's here. I
Kyla.
think he's on mute. Yeah.
Kyla Rowe. I believe Kyla is also unable to join us today, unfortunately. And Hunter Starr.
I'm here.
Okay, great.
Thanks, Andrew. I wanted to know, are you aware of anyone from the public that has public comments that they would like to make?
I'm not aware, but if any member of the public would like to make a public comment, please raise your hand using the raised hand function, and I can present you with a microphone and allow you to provide public comment for 2 minutes. I see James Gorton has his hand raised. So Mr. Gorton, I'm going to give you a microphone and I'll give you 2 minutes. You should be able to unmute yourself and share your public comment.
All right, thank you. My name is James A. Gordon. I'm an estate planning attorney and certified specialist in Pasadena. I'm speaking on the non-attorney ownership of law firms. It's a rule for the protection of the consumer, not the lawyer. It's to prevent a conflict of interest in the use of information gathered and representing a client from being turned against that client. A good example of the conflict of interest which would arise if non-attorneys were allowed to be owners of law firms would be the ownership of estate planning firms by insurance companies to gain access to clients' financial information and sell them annuities. In 2005, Family First, a large trust mill in Los Angeles backed by insurance companies, was doing just that and was shut down by the California Attorney General. A similar operation was shut down in 2003. The contemplated change in rules would convert this elder financial abuse into an allowed business practice. If persons not licensed to practice law are to be allowed to be owners of law firms, then the condition for their being able to do so should be to agree to be subject to the same rules of ethics in dealing with the clients of the firm as the licensed persons. And that's the end of my comments.
Thank you, Mr. Gordon.
Thank you, Mr.
I'm sorry, Dina, go ahead.
That's okay. I just wanted to thank you for your comments, Mr. Gordon.
Okay.
You want?
Yeah, thank you, Mr. Gordon. I just want to clarify, there are task force at the State Bar right now, which are studying possible amendments to that rule, specifically the Closing the Justice Gap working group in their development of a sandbox. That working group's next meeting is a week from today, Friday the 17th. This is the Committee on Professional Responsibility and Conduct. We do have responsibilities for drafting rules and considering amendments to rules, I just wanted to clarify that this committee is not currently considering any amendments to Rule 5.4 at this time. Again, only sharing that in case it's helpful to direct you to a group that might be more appropriate to hear the concerns you're raising. Is there anyone else from the public who has public comment today? If so, please raise your hand using the raise hand function, and I will present you with a microphone. All right, seeing no other hands raised, I think we can continue with the agenda.
Yeah, Andrew, would you like to handle the announcements and staff reports next?
Absolutely. So the first announcement I would like to make is I would like to introduce Bridget Grammy. She's here in the meeting today. And Bridget was recently hired at the State Bar as the Deputy Chief of Programs. And in this role, she'll be working closely with several of the program divisions of the State Bar, including the Office of Professional Competence, the Office of Professional Support and Client Protection, the Office of Admissions, and the Office of Access and Inclusion. And as a result, when COPRAC matters require executive management input or direction, Bridget will be a point of contact for us to help address those matters for staff. So you may be seeing and interacting with Bridget over the months and years to come. And just as a brief background, Bridget previously worked at the Center for Public Interest Law at the University of San Diego School of Law, where she served as an administrative director and supervising attorney for the center. And Bridget is not without knowledge or understanding of the State Bar and the State Bar's functions. She previously served on the State Bar's Task Force on Access through Innovation of Legal Services, which is a group I had the pleasure of being able to help staff. And she was very recently serving on the Closing the Justice Gap Working Group, another effort I'm helping the staff. So I was able to work closely with Bridget in her role on both of those committees. Of course, once she became hired at the State Bar, she resigned as a member of that working group, but she's still working closely with the efforts of that working group from the staff side. And Bridget is very familiar with the work of COPRAC, and we're excited to have her join the State Bar and provide oversight for the many activities that the Office of Professional Competence is currently engaged in. So I just wanted to provide that brief introduction. And of course, if anyone has any questions, feel free to contact me, and can always get you in touch with Bridget. Bridget, I don't know if you wanted to say anything in your own voice so that I don't have to speak on your behalf.
That's okay. Thank you for that really kind introduction. And as you all know, you're in great hands working with Andrew and Randy and all the staff at OPC, and just always happy to help if anybody has any concerns or questions. And thank you for all of your hard work. I know this is a particularly hardworking group, so thank you, and looking forward to working with you.
Okay, great. The only announcement I really have, which isn't very prepared, I just want to alert everyone, our next meeting is actually in 4 weeks. It's October 8th. I think it's the tightest turnaround we have on our agenda this year. So just planting that seed for any work or redrafts of opinions that need to be submitted for the next meeting. You'll be getting the assignments from Mimi next week or the week after. In fact, Mimi, another announcement, Mimi's on vacation this week, so you're just with me for today. But I did want to alert folks that there will be a short turnaround between meetings, and just to keep that in mind. The other announcement, which is again, not planned, but something I always lament over at this meeting, and that is, and those of you who've been on the committee for a few years have heard me say it, this is my least favorite meeting of the year. And the reason why is it is the last meeting of the current committee configuration. This committee year in particular will be losing a significant number of members, not just 3. We're losing up to 5 persons. And And that's tough. It's tough for staff. I'm sure it's tough for all of you. Thankfully, Dina has set aside time on the agenda later today for us to express gratitude, thanks, well wishes, and hopes for continued engagement professionally and personally, even though we won't all be together on this committee. But just in terms of an announcement from staff side, I just want to say for all committee members, not just those that are circling off, but in particular those that are, thank you so much for all the effort that goes on into your work. A lot of it is unseen and not known about, and I know you all know this, but so many people read these ethics opinions and they really stand the test of time. So many people go back to, think of the opinions we're looking at today. We cite the opinions from 1989, 1994, and many years since. So without blabbering too much and getting too emotional, I just want to express heartfelt thanks from myself personally. And I rarely, if ever, get to speak on behalf of the State Bar, but I think I can with some confidence say, the organization really thanks you all for volunteering and putting in so much time and effort. And with that, that's all I have to say. I know we'll say more when it comes up on the official part of the agenda.
Yeah, thank you, Andrew. I'll save my comments for later this afternoon. I did want to carve out some time where we could give some thanks and talk about this. It is a strange thinking about when you're just mentioning the next October meeting, how it will look a lot different. So that's always, as people know, a bittersweet thing. And welcome, Bridget. It's wonderful to have you here at the meeting today and a part of the State Bar. And I feel very excited about your new role there. And I'm looking forward to working with you and as part of this committee and in the future, hopefully. So I think right now we will turn to the approval of the open minutes from the last session. And does anyone want to make a motion to approve the minutes from the January session?
I'll move.
Thank you, Adam.
Second.
Thank you, David. All right, I will take the vote. Dina Roche,
Yes.
Ken Bacon,
I wasn't there, so I'll pass.
okay. Sarah Bonola,
Yes.
David Carr,
Yes.
Justin Fields,
Yes.
Toby Inlander,
Yes.
Adam Koss,
Yes.
Brandon Krieger, did we lose Brandon? I don't have.
Did that not come through? Yes.
Oh,
Sorry.
thank you. No problem. Amber Lee, Joel Mark,
Yes.
Kyla Rowe, and Hunter Starr.
Yeah.
Okay, great. Dina, I apologize if I could transition back to a brief announcement that I did intend to say, and I forgot as the emotions overwhelmed me. With respect to something to sincerely consider for those members who are sticking with us on the committee as we go through the opinions today, as well as if you peruse the opinions we're currently working on, please take time to consider opinions that are of particular interest to you and give a sincere effort to think about whether you'd like to volunteer to continue to shepherd those opinions along in their process. We will, as I mentioned, we're losing a significant number of folks. Of course, we're gaining 4 people, all of whom are really strong members of the committee. And of course, we're excited to have them, and they're going to be great contributors. But we could, in terms of allocating the resources of our current staff, of our current committee, please consider those opinions in which we will be losing folks, and send staff with an email with a copy to Dina, Sarah, and Justin, those opinions that are of interest to you. And staff will be making recommendations for reallocating the current committee members amongst those opinions. And it's great if we could have your input as well before we just stick you on something you may not be as interested in without knowing, having you shared your thoughts with us about those. So just keep that in mind.
Yeah, thank you, Andrew. That's really important. There's 2 opinions that are out for public comment that have not come back from public comment, and that's the file retention opinion, as well as the working remotely opinion. And so I think in the case, at least the file retention opinion, the lead drafter on that will be back. That's Amber. And then the 2 opinions that we're talking about today that we might either they'll be out for public comment or to the board, depending on how we move through our discussion today. But those are also opinions where we have lead drafters that are that'll be terming off. So just as Andrew said, and thanks for bringing that up, Andrew, thinking about these opinions, and maybe you've been involved on the subcommittee or you're really interested in it, they do need to be seen through all the way. And sometimes when we have these transitional moments, it becomes more challenging with, finding the continuity with members to take the committee, the opinion, whether it's responding to public comment or making final revisions. We have another one that's really close. And so that would be really important to get people interested and engaged in those opinions. So thanks for bringing that up, Andrew. Anything else before we start with the agenda?
No problem. And no, I am all done.
Okay, great. Okay, so I think what we will do, as you can see, we have today we're going to be focusing mostly on the 3 opinions that we identified in the email, and the and potentially talking about new opinions today. The 3 opinions that are in the agenda, the one that's come back for public comment regarding issues dealing with the clients with diminished capacity and that representation. We have the improper contracts provision opinion, and then we have the expert as a witness opinion. So those 3, which are in different forms along the way, are more robust and developed opinion. And I felt like there was going to be longer discussion potentially around some of these because we had a lot of public comment, or there's a lot of feedback, and there are kind of dense issues that we are structuring the meeting slightly differently in terms of spending more time with those 3 opinions, which I think will be helpful to where we are right now as a committee and sort of at this transition point. So the first one on representing a client with diminished capacity, Steve has taken the lead on that and has done extensive work with the subcommittee and his own drafting and considering and responding to extensive public comment on that, which is very much appreciated. And so I'm going to turn that part over to Steve to kind of describe. You guys you should have received and been able to review the public comment on that, as well as Steve's notes about revisions that he chose and then the revisions themselves. So hopefully he can kind of address those with the committee, and then we can talk through any issues or public comments that people have concerns about and the revisions reflected in the draft. So I'm going to turn it over to Steve. Thanks, Steve.
Thank you, Dina. And thank you to the subcommittee, who I'm sure will have further thoughts for being able to discuss, meeting and talking about this work. This opinion's been around for a while. We're 8 years in, and the most recent round of comments, I think initially my reaction was, holy cow, they raised a lot of issues here. But I think that when you actually look at it, a lot of them are smaller things. And by and large, what I've tried to do in the revisions and with the consent of the drafting subcommittee is to take virtually every smaller change that was suggested. And that allows us to focus in on a few issues where there were that were a focus of concern on the part of commenters. And I'll just mention 4 or 5 quickly, because they're all covered in the memorandum that I circulated before the meeting. And they're all, I think, with that memorandum, the changes in the opinion, I think, are fairly self-explanatory. So the first is an objection in the digest, which is repeated by commenters, particularly by Los Angeles County, through the opinion about the language that conduct that's engaged in an informed and disinterested judgment on a difficult question should not lead to professional discipline. The objection essentially was, and I thought this was an objection that was well taken, that we don't purport to have the authority to forecast professional discipline as such, nor do we have the authority to bind state bar prosecutors. So the language that's been substituted in the 3 or 4 places in the opinion here is should not be viewed as having acted unethically simply because in hindsight the judgment is later determined to have been erroneous. That's what I think captures the key insight that we're trying to talk about. The move here, if there is a move in terms of doctrine, is the notion that there is a concept of, if you will, ethical judgment, right? I think that's a very important concept in this opinion. It shows up in a number of different places. But I don't have any direct authority for it in California. I'll talk a little more about that in a second. But that's the first of the major changes. If you then go, if you can slide, Andrew, through lines 239 to 241, this issue also came up. Well, if you could jump just a little bit up above that to the first principle, there was an objection to the use of the restatement here for the proposition that the lawyer shall, as far as reasonably possible, maintain a normal attorney-client relationship with the client. The restatement there, as the stricken citation shows, is a citation to ABA Model Rule 1.14, which was not adopted in California. Our position, as you know, has been that the fact that language is contained in a rule that was not adopted does not mean that the principle is not available in California law if it can be found from other authorities. But the other authority here is the leading treatise, which states this as a principle that ought to guide people. The underlying point, though, I think, is continued in the next couple of sentences, where we talk about the fact that this principle necessarily flows from other explicit disciplinary provisions that we then discuss in the opinion. If you can then jump down to the next page, Andrew. So here's where the issue of judgment comes up again, right? And you can see the same formulation is adopted here, rather than is not subject to professional discipline, should not be viewed as having unethically, because in hindsight, the judgment is later determined to have been erroneous. Here, there were also objections to citation of the restatement, but those objections, as I point out in the memo, don't seem to be so well taken, because this is not a provision that's from an ABA rule, it's a common law provision. And so the point then becomes to show that that common law provision is consistent with California law, and that leads to something else that was objected to here, which was the citation of Smith versus Lewis. People looked at Smith versus Lewis and they said, that's a malpractice case, therefore we're opining on the standard of care. But the point here is not to opine on the standard of care, and of course we've expressly disclaimed that we do so, but rather to make it clear that what we're doing is that we're finding support in those cases for the concept of judgment, right, and avoiding hindsight bias. So that's the second area. The third area is at line 359, Andrew. And we can come back and talk about these, but I'll just take you through what I see as the key issues. 359 is the beginning of the discussion of discrimination. There's a big split in the commenters on the subject of discrimination. but nobody actually says we got anything wrong in this discussion, which is the first and most important test of an ethics opinion, right? Instead, we have a kind of Goldilocks dispute, right? Too much or too little, right? And my own read on that is that we went through the too much or too little and decided that this was just the right amount. I don't see any reason to think that we will do better by coming back at the question differently. We'll simply get new people upset with the balance that we've struck. In particular, if we reduce it, which is what all the bar associations want us to do, then the public interest lawyers will be upset with us. And so my own instinct is we've got it. We've got the law right. We've been clear. We've made a judgment that this is a reasonable amount of information to provide in terms of flagging the issue for practitioners, and we should stick with it. Next point is at 384 to 470. And here we're focusing on the question of authority to take protective action. The LA County Bar Association pointed out that the issue of authority is actually a common law question, not an ethics question as such. And as I thought about that, and also as I spent a little time talking with Brandon's good guidance, I had a chance to speak to the drafters of that opinion to hear their views a little more clearly, that letter. It seemed to me that was a reasonable point, and so the language has been modified here to make the point that what's called for here ultimately is a legal judgment informed by the duty of loyalty. But nobody had any real problem with our statement of the law as such, and so that hasn't been changed in any material way. It's just a question of sort of resetting this discussion with a slightly different framing. Finally, confidentiality, Andrew, and you don't really have to jump ahead because there's nothing concrete to talk about here. But there's the other big issue is the advanced consent portion of the opinion. And there were really two positions from the commenters. And the one that was supported by all the bar associations and also by the California public service lawyers, legal services organizations, was that the opinion should be bifurcated. There are sort of two lines of analysis there. One is really it's a different topic. And I think that our thought there had been, and we've discussed this before, that it's not a different topic if you're going to do a decent survey of the issues that apply to representing persons with diminished capacity. It's actually a central topic and one that is very closely doctrinally related to the whole question of the lawyer's ability to protect a client from harm. The second argument is really that the advanced consent discussion needs more work. But the suggestions for more work are things that we've either already worked on and added, or they're points that really I don't think we can elaborate on much more without making the opinion even longer than it is, and more unwieldy. So my instinct is that the bifurcation argument doesn't work. I think that was also the view of the drafting subcommittee. Then there's a question about the substance of confidentiality. And here the public interest lawyers repeating a point that some of them made in our earlier drafting process, advance an argument that there's a sort of fundamental flaw in the whole idea of advanced consent here. And that it should never be the case that a lawyer can act on the basis of an advanced consent. That a lawyer should always have an obligation to go back to the client to see if they still want what they consented to in advance. My view, at least, is that that's simply not the law. That there's express authority in California for acting on the basis of an advanced consent that's properly informed without further consultation. The case that they cite for that, the leading case that they cite for that, is a case about people who were denied the right to give informed consent, and therefore really doesn't apply in a situation where somebody has given an appropriate advanced consent already. So that's the simple version, right, of the reaction to the public comment. It's very distilled. There's lots more verbiage in the comment letters, but I think that this captures the essential points. And I want to turn it over to the subcommittee for their thoughts, and then we can open it up.
Hey, Steve, I think I would, if you don't mind, I'm going to turn over to see if Justin has any comments he wants to make. I know he has to be off for a little bit, and I just want to make sure we don't miss the comments that he has. And then we can go back to subcommittee members if that makes sense to you.
I forgot about that, Dina, and of course that's absolutely important.
Thanks. I'll be quick, and then I do have to jump off just for a little bit. I just had one comment. First of all, as usual, thank you so much, Steve, for not just a laboring oar, but how much thought you put into this. This is amazing. My only comment is on footnote 16. And you know what, my general, the subject matter of my comments has generally been about trying to avoid certain words that for me have a connotation with respect to mental health. And I think I'm sensitive to this because my wife's a school psychologist. And so the word that stood out to me in footnote 16 in the last sentence that was revised is the word assess. And it shows up twice there. And I hear that word almost every day in my household because it comes up in psychological evaluations and mental health evaluations. And so it just stood out to me as a word I think that we want to avoid, consistent with some of the other words. And so here's my proposed revision. I think that we should quote from what Moore actually says, which is consistent with, I think, what we're trying to convey about lawyers using their judgment, using reasonable belief about the capacity of their client to make the best decision they can ethically. And there's a great quote at pin site 896 from Moore, and it says something to the effect of, the attorney who is persuaded of the client's testamentary capacity by his own observations and experience, and who drafts a will accordingly, fulfills his or her duty to the testator. And so that language, I think, avoids the word assessment and captures in the language of that opinion what I think we're saying, which is this is about looking at the lawyer's reasonable belief. They don't have to make a mental health assessment, but they need to be, as the opinion says, persuaded by their own observations and experience, making, basically an informed judgment. And so I think that gets the message across without our having to, use our own type of diction, whether it's assessment or judgment or anything like that. And so what I was thinking is we could say instead, the court did not hold that the lawyer owed no duty to, instead of assess, we could say consider capacity, and then just quote that quote from pin site 896, period. or something along those lines.
I think that's an excellent approach. I think we can, Andrew, if we can keep the sentence, the court did not hold that the lawyer owed no duty to the client to, what was your preferred word, Justin?
Instead of assess, maybe something like consider.
I think consider. Consider is good. And then put a period. And then quote the sentence you describe in full.
Right. And it's pin site 896. And, you know, I was mostly saying it verbatim, but we can confirm that I didn't miss a word or two.
So I'm looking at 12, the page citations we're using here are 1200 to 1300.
Yeah, and I might have got a different type of citation, but with that language, the attorney who is persuaded, if we just do an edit find in the opinion using the pin sites that you've used, it'll come up real fast, and it's just one sentence there to quote.
I favor adding that. Let's find it. Like maybe, I don't know, Andrew, if you can find it, pull it up off the internet right now or not.
And if you can't, I can find it easily as soon as I return. So.
Shall we regard that as having been done?
Just wanted to note, assess is in the first sentence of that footnote as well. That was in there in the prior drafts. Is that from the case itself, or is that just our characterization of what they said?
I don't remember. I can look.
Yeah, I think that's our characterization. That if we want to change that word to, fine, but it didn't trouble me as much because it's a true statement. Like, a lawyer doesn't have to go to assess a client's capacity. So it's absolutely a true statement. What I thought it would be more helpful to revise is this last sentence where we're talking about what duty is actually owed, and then using the language from more. So I didn't have the same issue with that use of assess, but if we wanted to consider a different word, I see your point about that at the same time. That's my only comment. There's a few nit type things, and I can just send an email separately on that when I return. Thanks.
I have a couple comments, and some of them are small nits. If you guys, or if you want to hear, well, first of all, Steve, I echo what Justin said. You did a tremendous job here, and especially distilling all of that complex feedback and information to just really easy sort of decision points for us. For the rest of the committee, we talked at length about some of, I mean, we, as I think everyone is aware, but we've talked a lot in the subcommittee too about those particular questions about whether to segregate off the, have a separate opinion on advanced consent. And we felt strongly, at least in the subcommittee, and I know we've discussed this otherwise here along the same veins, that we think it's really important that it's part of this opinion. And so I support that and agree with that, that statement overall. And I agree with, the edits that you've made, Steve. I think they help strengthen the opinion and respond to public comment concerns. I have a couple minor things on in the digest, line 17. And this is a similar, because the digest and the conclusion have some similar language. So it's this language 17 where you say, a lawyer must sometimes make difficult judgments, plural, relating to the client's capacity. And then you said, providing that such a judgment, you turned it into singular here. And that's the same thing that happened in the conclusion. And I think we just need to either stick with whether it's multiple judgments that they're making or it is a judgment that they're making. I think there needs to be consistency with that in those two places.
I'm fine changing that back. I thought it was better to have it just be a single judgment because it was a judgment of that type. But I understand that it could be plural perfectly well, and I'd be fine with that.
Okay. And then the other, while we're on those lines too, the other thing I wanted to raise, which people can weigh in on, is that I like the way you've reformulated this to not include lead to professional discipline. You said the judgment is later determined to have been erroneous. We said that in a couple places, and we say mistaken in a couple places. And I just wondered, I think that obviously those are mean similar things, but I wondered if we wanted to use the same word both times, whether we wanted to say, considered to have been mistaken or a mistake as opposed to erroneous. Because sometimes an error applies, I don't know. I mean, I was going to say an error applies, someone made a mistake, but it's the same thing. But I think it seems like you did something wrong, where mistaken means that, to me, there's a little bit more of like a good faith basis to have reached a conclusion, but you were just mistaken about it as opposed to have committed an error. But so
That's fine. So you
I think I prefer that.
I think
I
that's
do, but
fine.
so that's on like lines 20, 21, and then 242 and 243. The rest of the times when you have that same formulation, you use the word mistaken. So, I mean, if other people are in favor of that, it's a minor point. I would be in favor of changing it. Does anyone have any opinion on that?
I had the same note, Dina, to raise. They're used interchangeably throughout the opinion, and I personally preferred mistaken as well.
Okay.
Yeah, I would agree with that. It seems like a small point, but I think, yeah, consistency is probably good. Mistaken isn't quite the same as erroneous.
And the
think that's
conclusion
I think
uses
it's a very good
mistaken.
point. What I like about what you're doing, you guys, is that you're focusing in on all the things I worried about when I was drafting, and so feels like really good vetting.
And then Steve, so then, and going back, yeah, it was in the conclusion, it was correct, I think.
Yeah.
So line 89 and 90, again, these are like minor things. So it's for these scenarios, the last question of the scenario, I wonder if we wanted to say in scenario one, where it's like, may lawyer represent client. I wonder if you say, is it ethical for lawyer to represent client? And it doesn't bother me as much in this scenario, but in number 2, the question presented is, may lawyer properly prepare the new estate plan? And I would want to put ethically there. And I just wondered if we want to insert in these questions at the end, may lawyer, or is it ethical for lawyer to represent, or may lawyer ethically represent the client in opposing, just include the word ethical in there.
I would think those are both. My own reaction would be yes.
Okay.
So
I
would change it to put an ethically before represent in line 89, and change properly to ethically in line 100.
Right, and then put ethically after lawyer in line 221.
Good.
221. 121, Andrew. I'm sorry.
I'm sorry.
Ethically take.
Yeah. Okay. The last question has the word ethical in it, so that's good. Okay, so line 92, 93. Sorry, there's not too many of these. 92 and 93. Lawyer has known, I think, and you want the word and in there, right? That's just a typo.
Yes.
Yeah. Okay. And then I have, sorry, go ahead.
Just was going to say those changes are suggestions. I can't remember from which bar association, but they seem to me to strengthen it. So yeah.
Line 418. There's just a repetition of the word, the requirement of is repeated twice. And
I'm sorry, what was the line, Dina?
418. Hopefully it's still 418.
Oh yeah, I
And then my last little note is 613. where I just want to say consent to lawyers, capital L disclosure of client, just to keep in mind. That's just a, yeah. And then in making,
Yes,
yeah.
got it.
Yeah. And then in making sure here, this is the same thing where we had judgments. I think that we have the plural judgments on line 624 and 625 in the conclusion. It's that same thing where we say,
So we just
that
change that right back, provided that such
Yeah.
judgments are, we just change
Yeah.
all that back. Just reject
Yeah.
the, just reject it.
Yeah. Yeah. But yeah, those are obviously all minor things, Steve. I think it's tremendous. I read it over again, with fresh eyes, and I feel like the analysis really holds it together. You've really addressed a lot of very, very difficult questions. I know that sometimes I felt like these comments would pull like one quote and say like, how could you say this? And I feel like it's all explained in this opinion, so if people read it, I think it really holds together. And these are difficult questions. I agree with the way that you've chosen to respond to the public comment, and the subcommittee has chosen to respond to the public comment. I think it makes sense to me. Thank you.
Andrew, I think we might, before we jump ahead, let's make sure we've got all that judgment language fixed, okay? Because then I go back to the digest and do it too. Provided that
Okay,
such
so
are informed, interested, they should not be viewed. They should not be viewed. Simply because prove them to have been mistaken. Let's do that in the digest now, just to make sure we don't forget. Those judgments are later. Okay. All right. Other members of the subcommittee?
I really had only one thing that bothered me a little bit, and that was the use of the restatement authority, and for the proposition that shouldn't be a matter of discipline. I think you fixed that very well, and I like footnote 10, a case I was not aware of, but I'm certainly glad I'm aware of it now. And I think it makes the use of the restatement, I think, stronger, to support the formulation that should not be viewed as unethical conduct, which I think is really as precise as we need to be. And so overall, I think it's a pretty impressive opinion in my view. And I want to thank you, Steve, for your hard work on it. It's going to be, I think, extremely useful to California lawyers. So it's pretty good.
It's high praise coming from you, David. I appreciate it very much. Have we got anybody else on the subcommittee? Adam, I think you were, you've had.
I was on the subcommittee. I don't have anything more substantive to add. I think you've done a great job. I mean, I voiced my comments in the subcommittee meeting, but I think we have gone through everything that needs to be done. There are people that love portions of it and not others, and people that want some cut out. And I think that the best route is to keep it how it is. I think that it addresses everything. I agree with the conclusions. I think the analysis is sound.
Other members of the committee?
So I was given pause by the fact that there's such uniformity of concern by other legal ethics committees that we should bifurcate the opinion. I don't agree with it, but it does give me pause that we're getting so much push in that direction from so many different sources. And I also was given pause a little bit by the comment by the Legal Services Organization that before the advance consent could be invoked, there should be communication about the fact that the attorney is about to invoke it. And I think your response, Stephen, that effectively negates the purpose of the advance consent is true. While at the same time, I am concerned about the duty to communicate before using, I mean, in order to give real validity to a client's right to revoke, it shouldn't be sort of a surprise attack. So I'm finding myself wrestling, and these are not specifically pegged to language in the draft. I think you've done a fantastic job with a very, very difficult issue. I'm still finding myself a little conflicted.
Let me just say, Brandon, that it also gave me pause that everybody thought we should bifurcate. But I didn't then see any really good arguments for bifurcation.
Yeah.
That's what I didn't see. I didn't see anybody saying, well, there's really going to be a lot of benefit if we hold that back. And it's clear to me that there's a real cost to holding it back.
Well, I also, I mean, the cynic in me was wondering if it was sort of like legislative games playing, right? That the advanced consent bifurcated opinion would be much easier to attack than this one is, because I think the most vivid context in which the advanced consents arise is this context, right? And so if your goal were to stop our advanced consent opinion, maybe it makes sense to bifurcate it and attack it when it's not attached to the most salient reason to use it. But I think it's key to the opinion. I'm concerned. I think you've taken the right course.
The second point, I think, about consulting and 1.4, I feel as though actually the comment to Rule 1.2, which says basically, if you've been keeping your client apprised in the ordinary course, right, and you've got an advance consent, right, you can go. Yeah. Without further consultation. And that it seems to me is also suggestive that it isn't a per se violation, right, to act on the basis of
anyway. Right. I am just struck by the fortuity, the idea that a client who happens to call up the day before and remembers and says, I revoke my advance consent, can stop the attorney, whereas the client who's just blissfully ignorant or not remembering the advance consent has it acted upon. I'm not sure that's resolvable, but it did concern me a bit. Yeah, because we're stepping into a sort of an uncharted area.
Absolutely, I agree with you. But this seems to me to be as close as we can get without undoing the whole concept of advance consent. Anyway. Other thoughts or comments?
I had a thought about the advance consent, and if I understand the criticism, one of the criticisms of the advance consent was that advance consent was in the proposed Rule 1.14. The Supreme Court did not adopt it. Therefore, the Supreme Court, I guess, has basically disapproved the concept of advance consent. Maybe I'm mischaracterizing the comment, but that was how I read it. And the opinion does go somewhere. It does go to uncharted territory. Well, not quite uncharted, but charted by ABA 1.14. Well, our previous version of ABA 1.14. But I think I think you've made the case for it very soundly. And I guess at the risk of indulging in maybe unnecessary speculation, I suppose if the Supreme Court thought there was something wrong with our opinion, they would have a mechanism to express that. I mean, I don't know. I don't think that's ever happened before, as far as I know. But it seems to me that even if we somehow got it wrong, there would have to be some way to address that. But I think we got it right. So I'm just curious if the Supreme Court did think we got it wrong, what would happen?
I think ultimately what we can say is what we're doing is construing the ethics rules as we think they read. Right. And the reason that 1.14, as we say in note 3 to the opinion, as we say in there, we're constructing our opinion out of existing California law. And this is our best reading of the ethics rules as they apply to this situation. We're not obviously guaranteeing that the California Supreme Court will agree with us. We never are. We never are, but I do think what we say in note 3 is right, which is that you can't regard rule 1.14 as overriding case law, right, that the California Supreme Court itself has handed down, right, or as overriding rules which they actually approved. And so when that's what we've built our opinion out of.
Yeah, and I don't think that we said there's 4 organizations that basically said it should be a separate opinion. 3 of them, one of them was based on length, and the other 2 don't say why, which we can conclude it was based on length, right? Or we don't know why. They just say you should consider a separate opinion about it. The only one that really sort of substantively raised concerns about it being a separate opinion, because like you said, Steve, they wanted to further study it or whatever, was the initial organization for disability rights. I'm not stating the organization correctly, but so there isn't a lot in there in terms of that concept of why these, I mean, and there's also overlap from some of these committees with certain people. I'm not really sure what the thread was as to why they thought it should be separated, but it's not articulated in at least 3 or 4 of the instances.
That's right. That's correct. I think LA says some things which I quote and respond to in the memo, and the legal services organizations say something else, but they don't back it up in any way that really suggests it's worth further study. Other comments or questions?
I don't know the answer to it, but is there anything that would have precluded the Supreme Court or some representative from making a public comment? Is that something they can do? I mean, if they had an issue with the advance consent and the interpretation of what the denial of 1.14 means, could the legislative or council or somebody for the Supreme Court chime in on public comments? I don't know how that works.
I don't know the answer to that, Ken. I do know that when OCTC, which is the person that would be in charge of any disciplinary proceeding, that when they have disagreed with one of our proposed opinions, they have not hesitated to weigh in. And they have not done so here.
Yeah, I may have just been reading too much into it, but the fact that they haven't said anything, I thought was something.
Well, I'll chime in. I don't think we can take too much from them having not commented, mainly because I'll answer the question 2 ways. It's a public comment. Anyone can submit comment, and that would include a staff person at the court. In my, I think I'm at 10 years now doing this, I've never seen a comment from court staff. And I don't know, if they review these. However, going to the core of this concern, I'm hesitant to say this because I like the gravitas that all our opinions hold, but at core, it is just an opinion. It could be wrong. Others might conclude differently. I'm not suggesting that's the case here, but I'm just reminding us all, it is simply an opinion. And when and if courts weigh in on COPRAC opinions is if and when, if ever, the opinion is presented before the court as supporting a party's case or knocking down an opponent's argument. And there are instances in which published decisions by the California Supreme Court have said, we agree with or concur with the analysis provided in State Bar of California Ethics Opinion 2002- what have you. So the only instance I think in which we could expect the court to ever weigh in is if and when, either in a discipline case or a civil case, this opinion is cited and presented in front of them for them to share their opinion.
I think Ken's point just now that OCTC hasn't raised in is more influential to me than the Supreme Court. But OCTC is the one that prosecutes these things. And as we saw last year, and Steve, you just said, if they don't like something we said and they said we disagree, they're going to let us know. And they haven't done that here, which, I mean, I don't think we can say that means they agree with it, but it definitely means that they didn't have that we aren't putting lawyers down a path of, we say you can do this, and all of a sudden they're about to get disciplined for doing exactly what we think they can do. I think OCTC would have chimed in had they disagreed.
I don't know that that's true. They're kind of distracted right now with a few other things going on.
This
So,
has been a comment.
So,
I know, but
should, yeah.
Let me just complete the thought, and at the risk of seeming biased, I guess I take the risk. They're not really, by and large, they're not really plugged into the world of legal ethics. I mean, I hate to say that, but they're really not. And it's entirely possible that nobody in OCTC on a systemic basis looks at the public comment. I'm just raising that to say that OCTC silence doesn't necessarily mean they've read it and approve it.
I'm not sure what benefit this speculation does for us. I think we should focus on the comments received and to what extent that influences the committee's opinion.
Thank you, Andrew. Thank you. I was going to say that. I agree with you that speculating about all of this isn't necessarily helpful. I share Ken's concerns, particularly about communicating with the client before enacting, on the one hand. On the other hand, I think that this opinion, and I've moved like 180 degrees in terms of the advanced consent. I think that this opinion is well thought out, well analyzed, very clear, and given the tools that we have to work with in terms of law and precedent, and the care that we've taken in considering the input from others, that it's the best that we can do at this point, and we put it out there. And I thank Steve for all the work, and the committee for really the care that's been taken with this.
I have a few wording suggestions if you're willing to entertain them.
Absolutely.
Okay, so right here at line 29, this isn't major. It just hit me when I read it. And the reason for the suggestion is to, we've been in the weeds on this for so long. I'm just trying to protect someone who's reading it for the first time and might not. I think we all understand what is being driven at here, and I'll explain that. And it's the use of the word "is" right here. So I would propose to change "is" to later becomes in order to avoid any potential temporal questions about, when to obtain the advance consent. So the sentence says, a lawyer representing a competent client may propose to the client that the client give advance consent to protective disclosure in the event that the client is incapacitated. I worry that that means advance consent at the time the incapacity has occurred. And so I'd like to say, in the event that the client later becomes incapacitated. I think that.
My sense is that that's a good change. Does anyone disagree?
That's just so others can read it.
That's a real improvement.
I think that's
I
what
agree
we
with
were
it.
intending. Okay. Footnote 3, we've been talking about this, similar to Justin's concern just about wording. I went and looked at the order. So the concept contained was grounds for rejecting it if the rule or concept is otherwise consistent with California's existing ethics rules. Great, this is a minor point, but the court doesn't reject requests for rule adoptions or amendments, they deny it. And I wonder if denying might be acceptable as opposed to rejecting, similar to mistaken versus erroneous. I just find it a little softer. Rejecting, and to my mind and ears, carries a more harsher result as opposed to simply denying. But I could be wrong in that, and that's just a minor suggestion. And again, the order says the request to adopt Rule 1.14 is denied. That's the word used in the Supreme Court order. I did confirm that earlier this week.
Well, but that would seem to apply very clearly in the first sentence of that, right? Denied the request to approve.
I apologize. Yes, I think that's where I meant for the edit to be placed.
But denied the request to approve, would that be appropriate to substitute that?
That's what I'm suggesting. I don't know if others agree.
I'm okay with that.
Okay, and then footnote 10. Sorry if these seem small. They are all big to me, but I can understand why others might disagree. So footnote 10, this last sentence, I worry it's a little too narrow because we just say permit consideration of ethics opinions. I would recommend say the rules of professional conduct also permit consideration of ethics opinions, comma, rules, comma, and standards from, and I would say even, or promulgated by other jurisdictions for guidance on proper professional conduct. The reason for that is we're not citing an ethics opinion, I believe we're citing the restatement, which I think is properly understood as a standard. And also the language I'm reading that I just read is language contained in comment 4 to 1.0.
Why don't you type it in, Andrew, and then let's look at it.
Sure. So the rules of professional conduct also permit consideration of ethics opinions.
I think I think that the addition of rules and standards is super helpful. I don't think promulgated by is necessary.
Okay, I think that's from the rule. That's why I added. I don't disagree. From other jurisdictions.
I think that's a great improvement. And anyone disagree?
And it's not limited here, although case law says that point. The rule does not say where there is no.
Terrific. I think that's a great change. I think that's stronger.
Okay, and then lastly, I think, and I might need someone to double check, I think in the, sorry, I'm not trying to make you seasick, down here in 623, this string site right here, I think in the digest, we also include confidentiality.
But we should include it here.
I think it's after communication. I don't know if anyone has that, so I don't have to scroll back up. I think
go after, that's the order. They're 1.1, 1.4, 1.6, 1.7.
I think confidentiality appears here in the digest. I just imagine it was
perfect. Yeah.
Oh, and then one other thing, sorry. Kevin Moore's in the back of my head saying you got to donate $1 anytime you use this word unless you can prove it. I don't disagree with the proposition that the rule doesn't have application when the court appoints. Do we have authority? If we want to use clearly, is that too strong?
Take it out. You can take it out. I don't have any commitment to it at all.
Or do we have authority?
Not that I can cite right away.
It makes perfect sense to me, and I'm not advocating for taking it out. I just wonder if the committee should consider, I mean, is there unanimity?
By the sense of other people. I don't have a strong view.
That we think is clear. I know this is not going to hold up voting out the opinion, but I just thought I'd raise it. Does anyone else care about clearly? I can leave it in there if no one else is bothered by it. Hearing no one else raising a concern, I will leave it in so I'm not the only one making the change. And then the last thing I will raise, and I hope it will just, and I'll fix this. I'll work with Steve and Justin to find this quote and make sure staff gets the language correct. I know we were discussing about bifurcating. There's also this comment about a separate process for which there is no separate process for ethics opinions. We've gone through our process quite dutifully. That was a concern raised. There have been examples in which opinions have gone out for a third public comment. You know, we could go for 45 days or something like that. I'm not necessarily advocating for that, but that is something that's within the discretion of the committee. And I think it's worth, you know, thinking about, at least for a few minutes, if there's any value or interest in circulating this for additional 45 days. The other option would be to vote to approve it, to be sent to RAD with a request that it's published on the State Bar's website.
How many rounds of public comment have we had?
Two,
right?
And the last opinion in which we went with for 3 was ethical obligations of an in-house counsel versus an outside attorney. That was back in 2018, 2019.
You mean when they're seeking advice from their in-house legal department? That's what you're talking about?
Correct. That was the last
Yeah,
opinion that I could find that we actually did a third round of public comment.
Well, I'll just weigh in, and then I want to hear from others too. I mean, I don't think it's necessary to send it out for another round of public comment, and I don't necessarily think it would be helpful, because I think that we got a lot of public comment during both rounds, which was wonderful and really helpful and helped shape our feedback and revisions of the opinion to make it, I think, a lot stronger and more precise about certain things. And I think that the areas where there's disagreement, we have carefully considered and discussed at length in multiple meetings. And so I'm not sure that, for example, sending this back out, if there's more feedback about advanced consent and separating it or it being longer, I mean, we've already sort of made a determination on those issues. I think we've addressed the issues that are before us. So in my view, I don't see that that would be something that would necessarily be helpful to the opinion. I think it's important enough that we should try to get it to RAD as soon as possible so that it could be published if that's what the path that the board decides to take with it. And I don't think the revisions are so significant that we need to have someone else look at them and say, hey, we fundamentally changed the tenor of the analysis or the opinion. So that's my view.
Let me
Agreed.
say a word. Let me say a word, Andrew. My test for whether you recirculate in these circumstances is whether you've made a substantive change in the basic analysis, right? And I don't think we have. The basic reasoning of the opinion is essentially completely unchanged from the last round. And that's despite a very substantial number of additional comments. And where there are the basic points of disagreement now are on the question of whether we should have an opinion that has advanced consent in it, and whether our discussion of advanced consent represents the law. And we've now been through that discussion twice, right? I don't see what the value in circulating for public comment again is.
I'm just going to say I agree with that, and I've actually had some people reach out to me wanting to know about this opinion and when it's going to make it out to, for publication. So I think there's a lot of interest in it. Another round's not really going to help.
Yeah, I agree. I don't see the point, as the opinion has been working on this for almost a decade. So it seems to me it should go to the board.
All right, that requires oh, sorry, someone else has a comment.
No, I just wondered if anyone disagreed with that or had different thoughts about that or any of the other issues that we've talked about. I just wanted to give anyone that hasn't had a chance to speak about it.
For what it's worth, my granddaughter just screamed her approval, so.
So we would need a motion and a second to approve the opinion with a recommendation that it go to RAD with a request for publication.
Subject to the minor nits and grammatical things that you're going to clean up in the interim. Yep.
Correct, absolutely correct.
I would so move.
Then I'll second.
Okay, so David is moving, Ken is seconding. I'm taking the vote now. Dina Roach?
Yes.
Ken Bacon?
Yes.
Sarah Bonola?
Yes.
David Carr?
Aye.
Justin Fields? Toby Inlander?
Yes.
Adam Koss?
Yes.
Brandon Krieger?
Yes.
Amber Lee? Joel Mark?
Joel?
Kyle? Is Joel there? Sorry, my camera's down as I'm looking at the voting slip.
Joel?
He is there.
Joel?
Joel,
We're
are
voting
you,
on opinion.
can you hear us? You're on mute.
If you vote, you have to unmute.
There. Yes.
Do you vote to approve that the opinion be sent to RAD for publication?
Yeah.
Great, thank you. Kyla Rowe and Hunter Starr.
Yes.
All right. Congratulations, everybody.
Yay. Thank you so much, Steve and the subcommittee. Wonderful.
That's great.
That is great. That is great. You know, it's only, you know, when you see those opinions and it's like starts with a 13, you're like, wait a minute, is that a typo? It's been around that long, but no, it's not. So that's wonderful. I mean, obviously it's had many iterations, and this is, yeah, so this is going to be, I think, very invaluable to a lot of people. So again, thanks to everyone for their hard work on it. I think we should get started on talking about the illegal contracts provision. We might not finish that conversation before lunch, and we can take a break at lunch and then go back to it. Just as a reminder, we had voted out this opinion for a round of 90-day public comment. We got public comment back and discussed that, I think not the last meeting, but the meeting before with the committee, some of the public comment and feedback. We then, the subcommittee led by David and Sarah and I made revisions consistent with the discussions we had at the meeting in, I think it was in May or June, and our efforts to be responsive to the public comments as best as possible. And so this is where we are with those proposed revisions. Hopefully you've had a chance to review those and refresh your memory about the public comment. I'll let David lead this discussion.
Okay, that's much better. Oh, there it is. Okay. Yes, we went through the public comment and we changed a few things and clarified a number of issues. There were other issues that we didn't think merited discussion. Let's see where to start. One of the comments was the idea that we hadn't sufficiently defined what we regarded the potential, you know, what it would mean to be advocating an illegal contract provision. And if we scroll down, I think, let's see where it is. Go down to the bottom of page, I guess that's page, yeah, keep going. Okay, where I'm trying to find the exact language. No, I think it's at the top of this page that we're on now.
Footnote 2, I think. Are you talking about where it describes?
Yeah, actually lines
illegal?
92, 93, 94 is where we clarified and we made it clear that what we're talking about is a situation where the lawyer has actual knowledge that under the controlling legal authority in that jurisdiction, that this was in an unenforceable or void contract provision. So we took into account the differences in states and really kind of pegged the idea that the illegality, what makes the contract provision illegal is that there's the highest authority in the applicable jurisdiction has said that this is a void contract provision. And I don't know the, you know, void versus voidable, but the idea is that there is no ambiguity here that the authority, the controlling authority says that you can't use this provision. We also included a discussion, I think it's at the, yeah, immediately above, we cite to rule 1.0.1F, which is our definition of knowing. And the definition refers to actual knowledge. And I think the distinction here is actual knowledge versus some type of constructive knowledge. Although 1.0.1 might be a little more precise about that. Clearly, a situation we were contemplating is where the lawyer absolutely knows, actually knows that in this jurisdiction, in the applicable jurisdiction, the controlling jurisdiction, this provision is void. So I think I think this definition cures some of the uncertainty, if there was uncertainty, about what that meant, what that means. One of the other issues had to do, and if we could scroll down, I think, to the last page. I'm trying to look at the red line on my computer at the same time. Yeah, we added a footnote. One of the issues was the idea that whether a lawyer had to fully, when we come to the discussion of what happens when the lawyer pursuant to 1.13 has to go up the ladder of the organization, and 1.13 talks about unless the lawyer determines it's not reasonably in the interest of the entity, the lawyer must report up. And we had a footnote. Yeah, footnote 16 is what I'm thinking about. We clarified that we assume the in-house lawyer would be permitted to terminate his representation with respect just to that matter, and would not be required I'm sorry, to quit their position. I couldn't really find any authority clarifying 1.13 on that issue, and I think we agreed that we don't really need to clarify it necessarily. Maybe that's an issue for another day, but for our purposes, I don't think we need to clarify it, and that might be the genesis of a whole nother ethics opinion. So that's yeah, footnote 16 addresses that issue. There was one criticism that said we should include an additional scenario where the court finds that the contract provision is void or unenforceable, but the court's decision is wrong. And we discussed that, and we rejected inclusion of that type of scenario because it essentially, I think, undercuts the entire opinion. I mean, we're basing this opinion on what the law is, not what the law should be. So we did not include further discussion of that particular, the idea that maybe the court got it wrong. Well, maybe the court did, but the court's the one that says what the law is. So that discussion isn't really helpful to the opinion. Let's see, what else did we change? Not a whole lot else. I think we left most of the discussion of Rule 4.1 and 4.2 intact, and I think that's on the page immediately above. Yeah, here we go. And we continue, there's some criticism about using the South Carolina opinion. We thought it was still of limited use, of limited help, and again, there's not much authority in this area, so we left the South Carolina citation in the opinion. So the opinion overall, I don't think where we're going with it really has changed, but we've corrected a few things that I think were valid criticisms. We took out some of the discussion about a little bit of the discussion of BNP code 606A-B, I'm sorry, 606A-D, the duty to use means truthful, because there is some authority that only applies in a litigation context, although I will say that it's not entirely clear. It's kind of it's really dicta in a Supreme Court, I'm sorry, a review department discipline case. It's not really a holding. So it's just some slight authority that it doesn't apply in the transactional context, but it's not really clear. And I think those are the high points as I recall the discussion. The opinion hasn't changed a lot, but I think it's responsive to the public comments that we received.
Thanks, David. Sarah, do you want to add anything about some of the changes to 4.1 or anything that you were involved also in part of the discussions that you can think about to add to this, or?
No, the one thing I just wanted to, I think, David, you already covered it, but I forget what footnote is now. I was trying to look at my draft. I think it's the footnote about that was added that we're assuming the lawyer can withdraw from the particular matter.
I think that's footnote 16, I think.
Yeah, that's what I added when I revised that section. And if you want, I can explain my thought process behind that.
Sure, if you want to explain your thought process on that one, yeah, because I was going to suggest perhaps some suggestions on that footnote, but I'll wait to hear your thoughts first.
Yeah, no, I mean, I'm reading it again. I'm like, I probably would want to say it slightly differently, but what I think one of the things that we addressed in response to public comment was, you know, we had a very cursory discussion in the prior draft, and not that it's too much more robust, but about the duty to withdraw from the representation. And I think our prior language suggested that, well, I think first of all, we didn't really make it very clear when the circumstances would warrant permissive withdrawal versus mandatory. So I think we tried to clarify here and in the digest and later that, and we might want to add a word. I have a suggestion for that, some of that language in the digest just to clean that up a bit. But the permissive would be the circumstance when, you know, HR is saying, where you're making the recommendation as in-house counsel, don't use the provision I recommend against it, it's illegal. And they say, okay, thanks, but they go and do their own thing, right? So this isn't about reporting up, this is separate about the duty to withdraw, and whether that would be permissive or not, and that we viewed that would likely be a permissive situation, not necessarily mandatory, but that mandatory, and if you want to scroll to 166, Andrew, that mandatory would arise more in the situation where they not only ignore the in-house lawyer's advice, but they insist that the lawyer be actively involved in promulgating or enforcing the provision, in which case that would likely require a mandatory withdrawal because, you know, based on the rules and being something that's in violation of the rules of professional conduct. So that we tried to separate that. The prior language suggested that if they made the in-house lawyer's continued participation as a condition of employment, we sort of felt that was problematic because we didn't really want to suggest that, you know, what the in-house lawyer had to do if it's a whistleblower situation. We're going to get treading into water that we maybe didn't want to tread into on that. So the point of the footnote 6, which really didn't have to do with 1.13, but was supposed to address issues related to withdrawal, was the question of that they would, you know, that we assumed that the in-house lawyer could be in a situation where they said, you know, I'm not going to be involved in that further. They might have duties to report, but that wouldn't mean that they had to quit their job. We didn't want to suggest that you know, in all these situations that the in-house lawyer would have a duty to quit that person's job, that lawyer's job. So that was the purpose of stating that footnote, is to address comments where people were asking, are you saying that that lawyer, that in-house lawyer would have to quit basically as a part of terminating the representation. So this was an effort to address that, and definitely open to feedback from people about massaging that language, or is it effective? Is it sort of the right approach on that? I didn't, you know, based on our discussion, didn't feel like we wanted to opine on that issue of whether or not, you know, they might be required to terminate their employment.
Thanks. And so I know we talked about this briefly in our subcommittee discussion, and I understand that we don't want to get into issues, you know, about whether withdrawing in terms of outside of the rules of professional conduct, in terms of from an employment law perspective or from a whistleblowing perspective, but I still think it would be useful to provide some guidance here in terms of, rather than assuming, to provide some guidance in terms of whether the in-house counsel could withdraw from the particular matter under Rule 1.16. And we also discussed possibly limiting the scope to exclude that matter under 1.2. And by just withdrawing from the matter, they wouldn't need to resign from employment as long as they could effectively withdraw from the matter and not represent the company in terms of seeking to enforce the illegal provision. And I think that would provide some helpful guidance for in-house counsel. I know that this issue is come up, and it was raised in the public comments as well, but it's come up too in the past in terms of this type of situation when there's an issue that requires in-house counsel to withdraw, or whether withdrawing from just that matter, or does the in-house counsel actually need to resign? So I think it would be useful if we could write a little bit more guidance while still excluding, as I think the way it's drafted now in footnote 16, still excluding kind of a broader discussion of, whether they have to withdraw based on HR's continued conduct and getting into too much detail. But I think applying the rules here would be useful.
Well, I think that's really, I think that there is a necessity for that kind of discussion. I guess my feeling is that that's a weighty topic in and of itself that has to do with the construction, the interplay of 1.13 and 1.16. And in fact, that's something, and if we're talking about new ethics opinions, to me, that's a weighty topic that might justify an entire ethics opinion. I think we can include discussion, and I think 1.2 says you can limit your representation if it's reasonable under the circumstances. So I think that might be a springboard to talking about, what kind of duty in-house counsel has, and whether in-house counsel can sort of selectively withdraw from representation while remaining employed. I guess my concern is that really getting into the weeds in that discussion could generate a quite a lengthy discussion that's slightly, it's related, but it's somewhat apart from the main point, which is that the lawyer has an ethical duty not to counsel the client to violate the law. So I guess that's my objection to really going too far down that path. But there's certainly a need for guidance there, and maybe this is the right vehicle to do it. Maybe not, but it seems to me it's a pretty big subject.
Yeah, maybe we can open that up. I mean, there are a lot of small revisions to this, and so I think it reads differently. And so I think we would be very interested in feedback on, all of the revisions to the opinion. But maybe we can just talk specifically about this issue, about the termination part, and what people think about providing more guidance than footnote 16. It could be modified to include reference to the rule, or to stay away from more analysis on that and how they think this reads, because it's a slightly different formulation than what we had originally drafted. And in response to public comment in our discussions, and just wanted to get feedback from people about what they think. Do they think that the analysis holds together?
That's always, I think I had raised this in prior meetings. I guess the practical realities in an in-house counsel situation of withdrawing on a specific matter while remaining employed. It's not necessarily something that's within the discretion of the attorney, whether, if they take this conduct and try and withdraw on a particular matter, can they stay employed? Are they going to get fired? It is a pretty weighty subject. I'm not sure that we adequately address it in footnote 16.
I think David is right that it's a very big topic. I think the question of when an in-house counsel, how and when an in-house counsel withdraws, is a very, very big topic. A hard one to answer in an opinion that's nominally focused on the question of, it's not integral to the discussion of this issue, it seems to me. And it's hard. And so my instinct would be not to treat it. I'm not sure the formulation in the footnote is exactly correct, but that level of depth of treatment seems to me to be about right. Do you want to talk about other aspects of this opinion or not?
Yeah, feel free to give feedback on any other aspect too. Yeah.
Okay, my first one is in footnote 2. And it has to do with the sort of walk back on in terms of what constitutes something that one knows is illegal. And it says here, one of the exceptions at the end of the footnote is that the provision might be enforceable under some circumstances, right? Maybe it would make some sense to say enforceable against the person, right, who is being asked to sign it under some reasonably foreseeable circumstances. I don't know. I'm trying to, it just seems to me that the way it's written right now, it could be enforceable against somebody somewhere under some circumstances. But if the lawyer is sitting there and it couldn't be enforced against this person in any reasonably foreseeable circumstance, then that would seem to me that we'd want to say that was a violation. So some circumstances, what would you think about? I'm really asking the drafters, what do you think about the idea of saying something like enforceable against the person to whom it will the persons to whom it will be presented under some reasonably foreseeable circumstance?
I think that, not to put you on the spot, sir, but I think you drafted this and maybe you could give feedback on that. I was also wondering about, I'm looking at more detail about the addressing provisions that are legal but against public policy, like what would be an example of that? I'm not thinking about that now. I mean, I do think it's important to have a description of what we mean when we say the word illegal and be on the same page about that. And I think it's helpful to have a footnote describing that.
Yeah, so this footnote I drafted based on the public comments we received, where they wanted it to be clear, and the other edit we made throughout was just say that the provision is unambiguously illegal. And so this was just trying to address concerns where there might be a situation where the provision might be legal in certain circumstances. And so I do think actually, I like Steve's edit here against the person who is being asked to sign under some reasonably foreseeable circumstances. I like the term reasonably foreseeable circumstance. And I guess adding against the person who's being asked to sign is also helpful as well, because then it's also, I think it just clarifies even more that we're not addressing a situation where there might be a particular employee where the provision would be enforceable because they provide services in other states, or just that there could be so I think this helps clarify it. So I'm in favor of this edit. I think it's clearer. But
Just want to confirm the intent is circumstances plural.
Yeah, I think so.
yeah.
Andrew.
Okay.
One other change in that footnote, would it be, I think this is a minor change, but in that same sentence, it says another court has ruled or would rule otherwise. I would wonder if we want to say another court in the controlling jurisdiction.
Yeah.
Yeah. And in looking at this footnote, I think we could delete some as well.
I'm sorry, where's the sum?
Under some reasonably foreseeable circumstances, the last sentence. Yeah.
My next comment is over at 9. I'm in the red line at line 98. I think it's a little better to say, instead of allows the lawyer to be competent, I would say fulfill the duty of competence. And I think that the way it's written here, a lawyer to fulfill would imply that when we should say consulting a lawyer, the lawyer reasonably believes to be competent.
I'm sorry, Steve, I'm not where's that next
Right at the end of the
adjustment?
sentence, it says a lawyer they reasonably believe. The antecedent is a lawyer, so I would just say the lawyer. And it would be lowercase, the lawyer reasonably believes. It's just an agreement thing. At 103 to 105.
Wait a minute, we got to put that consulting a lawyer, the lawyer. You have to add another lawyer.
There, yeah. At 103 to 105, might be grossly negligent to the extent lawyer's conduct reflects deliberate and reckless disregard of the lawfulness of the agreement. Is that the standard for gross negligence? If it is, we should cite some authority for it. I'm not aware that you have to show deliberate and reckless disregard in order to establish gross negligence. That sounds more like recklessness. Or even if it's deliberate disregard, it could be willful blindness, right? But gross negligence seems to me to fall. Anyway, I'm not taking a view because I haven't researched it. But if that is the standard, we should have better authority for it. And if it's not, that might be tweaked a little bit.
Steve, on that point, there is a case, I think it's County of Santa Barbara versus somebody, that basically interprets gross negligence to be a state of mind that is almost comparable to recklessness. And I just know that because in discipline cases, we delve into that quite a bit. And I just off the top of my head, there is some authority that gross negligence is almost as bad as, almost to the point of recklessness.
Well, my instinct would be to cite that authority then.
Yeah. Okay.
Right? And at 122, if the lawyer assists the client in promulgating, the lawyer's conduct can be characterized as a misrepresentation. That doesn't, I don't know what the right language is, but that doesn't feel quite right. Right? Can be characterized feels it you know, it may be, it is, or may violate because it is, or something like that. I can be characterized strikes me as not a formulation that we use very often. it sort of suggests there's an argument that it could be, right, which maybe is, or it may sometimes be. That's that, and that's what I got.
Do we want to, sorry, do we want to change that to maybe, maybe a misrepresentation by omission? What do you think, Sarah and David? I'm not sure who drafted this part, and I don't know. Or if maybe we did on the fly.
I think this is an edit we made during our group discussion, but I'm maybe a misrepresentation. I'm fine with this edit here.
Yeah, I think one of the things we were sort of struggling here with in discussing like 4.1A and whether B applied and whether it was a misrepresentation of law or fact was that based on our fact patterns, which were pretty sparse, there wasn't a lot to conclude that it was, definitely a misrepresentation of fact. And maybe, depending on how that information was ultimately presented, which is sort of like, it sort of takes off at the point of after scenario 4, where the in-house HR department says to in-house lawyer, we want you to be involved in promulgating or enforcing the agreement. And so we don't describe those conversations or what takes place or what the lawyer may consider doing with respect to that. So there was a little bit of the need to, we didn't want to say that in our fact pattern that there was, a misrepresentation of law or fact. But anyway, this is a much better formulation of what that is, because I do agree if they do that that may be characterized, it may be a misrepresentation. I think we would probably agree that it was, depending on the circumstances, that it most likely was. Well, thanks for that feedback, Steve. We can start with some other comments. We have about 5 more minutes until I think we're going to break for lunch, or we can, if someone has some other short comments, or we can take this up further discussion after lunch.
So I had a quick point, and it's at a couple, but none are too major. But right here, while we're on the screen, just a little confused. So this sentence beginning right here, California state statutory law. There's a reference there, but I think we lost the citation of the statute unless, and then we lead with the rules and it's followed by the citation of the statute. So anyway, it just read to me as strange to say California statutory law states the duty in broader terms, but we're not really leading with that proposition.
Yeah, I think that is language that, in light of the fact we excised 606AD in the next sentence, that sentence should have come out as well.
Okay, so that was my question. We want to just lose this sentence here. Is that okay?
I think
So
that fixes the problem.
Yeah. Let me just read it really quickly.
And I think we need to capitalize enforcing, right, then? For start, so is it, no,
I'm sorry, the sentence, it's hard to see.
Yeah, it's sometimes hard to read the.
So the sentence, exactly, begins using enforcing. And a couple other nits or small things I think can easily be resolved offline.
Okay. why don't we go ahead and make plans to break lunch? I have a couple other comments too. If anyone has extra time over lunch to review this, it would be great to get feedback from others outside of the subcommittee about this, because I know we're we'd like to vote it out for another round of public comment. And, you know, there are some, I wouldn't call them significant changes, but some changes to our thinking on this. And I want to get everyone's feedback on it, make sure we're comfortable and that we're putting out the best product for the revised draft. So anyway, let's go to lunch and then group back together at 1 o'clock.
All right, sounds good. And that has been accomplished, so we are back.
Great. Hopefully everyone had a relaxing little lunch. I think we're going to pick up our discussion, or we are going to pick up our discussion on the illegal contract provision. We sort of talked through some of the revisions that we had made based on the public comment. And I know we didn't get finished hearing everyone's feedback on certain things. And during the break, Sarah had also circulated to David and I a proposed revision to that footnote 16. So, so maybe she can email that to Andrew, who could put it up there, and we could sort of talk through that, because that was a question about sort of how far do we want to go with that footnote with respect to, you know, weighing in on the issue of what the in-house lawyer may be permitted to do, what would be grounds for termination, or whether they would be required to terminate their employment in those situations, which we had some preliminary discussions about whether or not we thought that would be appropriate or not appropriate to weigh in on. So I don't know where, I don't know if Sarah's back on or not. I can forward that to you, Andrew, but maybe we could also get in the interim other feedback from folks about that issue or other issues in the opinion, or questions they have about some of the revisions, what they think is works, doesn't work, that kind of feedback.
Well, I apologize for missing the initial part of the discussion. I have some comments, but I think I should probably go last so I don't interrupt the discussion you're already having. So if other people have comments, please jump in. Otherwise, you know, I can offer something, but I'd prefer to go last so I don't duplicate.
I've received the language on footnote 16, if you want to try to address that now, Dina. Or do you
Yeah,
want to
I mean,
solicit?
well, I actually, let's see about what I think I'd like to see if anyone has other comments about other things in the opinion, and then because I think that might be a little bit of a conversation. So
Okay, got it.
And I think that the question about how we handle the that issue about withdrawal, you know, I think is something that we all want to be comfortable with, hopefully. The one thing I was going to suggest while you're writing this digest, Andrew, is that on line 20, where the line where it says, in the event the lawyer may withdraw from the representation, or depending on the client's continued conduct may be required to do so. I was going to suggest that we say, in the event that the lawyer is permitted to withdraw from the representation, just to distinguish the you know, mandatory versus permissive there. I think it makes that clear, and it would be repeated in the conclusion if people agree with that.
So I'm sorry, could you repropose your edit, and I will try to capture it so you can see it.
On line, yeah, 19, in the event that lawyer is permitted to or yeah, just yeah. Well, yeah, just it's taking out may instead of may, just putting is permitted to.
Got it.
Does that make sense to people on that issue? Or did people find that didn't need to be clarified in that way? I just thought there was some questions about just distinguishing between permissive withdrawal and mandatory in the language.
I had the same thing and I wrote a note, and my suggestion was should may be required read will be required to do so. So at the end, because I thought the contrast was not stark enough with may withdraw and may withdraw and may be required to do so. They both read permissive to me, but I was addressing, so I was saying depending on the client's continued conduct will be required to do so, as opposed to may be required to do so. Either it becomes mandatory or it doesn't. That was my view.
Well, it may be required because we don't know what the client's continued conduct is. So we were discussing how if the client insists on the use of the illegal provision against their advice, right, the lawyer can't participate in presenting against a third party. And we're saying in that event, they're permitted to withdraw. But depending on the client's continued conduct, which we described later, it could be like that the client's insisting that they are involved in enforcing or promulgating the agreement, they might be required. Like in that instance, of course, they would be required to withdraw, but we don't know what the client's conduct is, so it depends on that. That's why there was the may, but that could be better stated if people had a similar response.
That was my response looking at it. I mean, the contingency is contained, I think, and depending on the client's continued conduct. So I think should be is a better edit because you've already introduced the contingency idea in the clause before it. So I think it does read much better if it says should be as opposed to maybe, because as it stands, it's not exactly, I don't think it's ambiguous, but it seems, I don't know, a little kludgy, maybe, I don't know. I think Andrew's edit is good.
You're suggesting should be. I said, I'm only suggesting will be, because again, I take Dina's point, I guess, and we should think about it in the broader context. Reading this sentence in isolation, you have may withdraw and then may be required to do so. With the use of may twice, again, in the note I made, it just the contrast wasn't stark enough for me. So that's why I came up with my suggested edit, but that's not to say that that's the only way it can be achieved. And of course, I recognize there's nuance, but if you want to set up both extreme options, at some point you may be required to do so. I just hate to think that the rules allow you to consider whether you can withdraw in an instance where it's required under the rule. But maybe that's not, and I might not be remembering this portion of the analysis in the opinion correctly enough. Maybe it's not framed in that manner.
Yeah, I mean, the analysis changed a little. So like the prior language, which we just said in that event, which is the event we describe above, which is like that the lawyer, the client insists on using provision, the lawyer can't participate. And we say in that event that they may withdraw from the representation, but is not required to do so. That was our prior formulation, but I don't think that really captures what we're trying to say in terms of like the mandatory aspect, that there could be a situation where it is required, but maybe we don't feel that's necessary to say in the digest and should go back to the original formulation. So that's also a potential.
So, the contrast derives from this preceding sentence, right? If the client insists on use of the legal provision against lawyer's advice, the lawyer may not participate in presenting the legal provision against the third party. In that event, the lawyer either is permitted to or may withdraw from the representation, or, and I agree there's a big caveat, but I think it's captured here, depending on the client's continued conduct. I see what you're saying, will be required to do so, may be required to do so. I still think use of will instead of may, in my mind, drives the contrast. Again, more starkly, I don't know what other word to use there, but if others feel it doesn't accurately capture what the opinion's saying, then, I'm not advocating strongly for it. I just think it might be a helpful contrast.
Yeah, I don't like using will here, given for the reason Dina said it, because we're saying depending on the client's conduct. But I would be okay with going back to how we originally drafted it, including, I think, the clarification with is permitted to withdraw. But I would be okay with the original version. But I think if we're saying depending on the client's conduct, then I don't think you can say will be, because it depends. But one other just minor edit here, I think we still need, I think we should still have the comment after in that event. In this sentence, I think it was struck from looking at it.
I'm not seeing in that event.
Line 19, it's just the clause in that event, comma. There was a comma, and I think you took it out.
Oh, sorry. Gotcha. I see.
I mean, I guess the tension here that I see from a drafting perspective is that the digest captures a scenario where, the client insists on using it, the lawyer can't participate. But in our actual analysis and discussion of this opinion, we kind of go further and say, well, what about the scenario in which the client insists that you continue to use it? And we're saying, of course, in that case, you couldn't, and that would trigger a mandatory withdrawal requirement. And so, that's not really captured in the digest. I'm not saying we have to capture every point that we make. So I think that was an effort to reflect that we don't want someone who's cursory, just reading this saying, oh, in that situation where a client insists on using the contract, that's not going to rise to the level of a mandatory withdrawal, because there are facts in which it could, right? It just depends. So, the way we had it before was accurate, but it maybe didn't capture the entire analysis of the opinion. That was the only thing. So
When you say the way we had it before, if I do not accept this edit, if I reject this red line strikeout, would that go back to what you're describing as the way we had it before?
Yeah, I think so. I mean, Mimi used to have a thing where she could toggle, but yeah.
Yeah, she's a magic maker.
The magic of word processing.
Let's see what I can do. Oh, look at that. I got it. Okay, let's try to read it with the way it was previously. Does this make people feel any more comfortable?
But because I still think that there's circumstances in which that situation could rise to a level where the person has to be required to do it, which is if the client continues to insist that they are involved in it or makes it, I don't know.
I would agree. This doesn't really end the analysis the way this sentence ends now.
So Dina, are you advocating going back to your original revision?
I mean, kind of, but I don't. I mean, it's stuck with me because it's like there's something about it that doesn't work for me, and so I'm open to suggestions about it. And I think part of it is because of the formulation of the sentence before it, which is completely accurate, and I didn't want to go back and change that, but it doesn't address that part of the analysis that relates to the fact that it's what about a situation in which the client insists. So anyway, do you have thoughts, Justin?
I mean, yes, I prefer the formulation that's right now present on our screens because it provides that there's sort of a spectrum here. And it's the digest. It's not, we haven't gotten into the actual facts of our opinion. And so it's kind of leading the reader to this idea that there may be circumstances where your withdrawal is required. And now let's go talk about the specific facts of our opinion and see where that leads us. That being said, assuming we're not voting this out today, it seems to me that we should flag this sentence, see how the analysis in the body of the opinion plays out, and then see if we, based on how that analysis plays out, need to revise this further. I think we're kind of a little bit maybe premature in trying to finalize this digest, but given how the lay of the land right now, I prefer this. It was subject to seeing how our analysis evolves in the body, and then of course in our conclusion. I think this is how it's presented right now on our screen is consistent with what we have in the conclusion. So again, I think we need to flag the penultimate paragraph of this opinion for potential revision, depending on how the body of our analysis, the body of the opinion plays out. So that's a long way of saying I think this is good enough for now, and maybe we should consider it later once we finalize the opinion for further.
Okay. All right, so then why don't I just turn it over to other people who have comments about any part of the opinion?
I can offer some thoughts.
Great.
And apologies if I repeat anything that was said when I was off. Please just cut me off, cut the mic. So what stood out to me is the use of the unambiguously illegal. I didn't understand it when I first read it, but then I got to footnote 2 and I started thinking about it a little bit further, and then I understood it. So my point there is, in the digest, it kind of, as a civil litigator, when I saw unambiguously illegal, I was kind of like, well, what does that really mean? And so I have a couple thoughts on that. One is to put up front the footnote right there when we talk about unambiguously illegal, to cue the reader to what we mean by that. So then when they see that phrase in the opinion, they know what we're talking about. Or to explain it in the digest in more, sort of a cribbed version of footnote 2, just so the reader isn't kind of unsure what that phrase actually means. That was something that stood out to me for consideration.
And Justin, just so you know, there is some revisions to that footnote too, if you want to look at that. That's what.
Okay. Yeah, I mean, just that seems fine to me. My main comment is more of structurally, where do we want to explain? How do we want to explain what unambiguously illegal means? And it seemed like an important term that we're introducing in the digest.
Well, do we need to introduce it? I mean, can we just say illegal and say this is what we mean when we use the word illegal and have that footnote?
That also works for me. And then if we use that term in the body, the first time we use it, we can explain, hey, when we say unambiguously illegal, here's what we mean. We're not talking about a situation when there's some argument for a good faith modification or any of that. We mean, when we say this, we mean illegal under all circumstances. And that's what we're assuming here. And so, yeah, if you take it out of the digest, I suppose its current location right there in the first sentence of the intro helps. I think, though, that the footnote would then need to be modified just to explain, to tie the footnote to this phrase unambiguously illegal, because as I read footnote 2, that it's sort of defining what we mean by that, but we don't expressly say it. So I think making that connection to our explanation of footnote 2 and the use of that phrase, why it's relevant to kind of confining the scope of our opinion, I think that that would be helpful.
So wait, I'm sorry. I think in my mind, there are two suggestions being made. One is to remove the word unambiguously here, and then also to bring footnote 2 down to the end of the sentence. Is that what's being suggested, and is that agreed to, or am I missing both points on that?
Well, I personally don't care where the footnote is if we're removing unambiguously from the digest. What I'm suggesting is that we, and the drafters, please tell me if I'm wrong, but as I read footnote 2, it's sort of explaining what we mean by unambiguously illegal. And so what I'm suggesting is we tie footnote 2 and just be clear that when we say unambiguously illegal, here's what we're talking about. This is not, this fact pattern that we're presenting, our analysis is not intended to address, you know, provisions that are legal but against public policy, or there's some good faith belief that it could be modified. And so when we say unambiguously illegal, we're talking about that circumstance. And that's what we're addressing in this fact pattern. We don't quite make that connection between footnote 2 and our use of the phrase unambiguously illegal.
Yeah, I
Okay.
agree with you, Justin. I think I agree with you completely. I think one of the questions I was raising, and that's for like the committee to decide too, is that do we need the word unambiguously? We might like it and we might want to use it, but I think we need to be consistent about it. If we're going to say when we use the word illegal, this is what we mean, and we mean unambiguously, that, you know, and describe it that way. But I think we need that. I agree that there needs to be consistency with that, and I would be interested to know if people want that description or they want just the definition, or, you know, how people feel about that.
No, I think that's a good change, and I think it does need to be defined because unambiguous is itself ambiguous. So the term, so yeah, I think it's a lot cleaner to take it out, and then I think Justin's suggestion is a really good one. And then make footnote 2, move footnote 2 to the end of the introduction.
So just to clarify, it sounds like, David, you're talking about, and I agree with moving the footnote there. So it sounds like you're in favor of removing the term unambiguously illegal throughout the opinion, and we're just making it clear up front what we mean by the term illegal, by including that footnote. Is that what you're suggesting, David?
Sorry, Justin, if I understand your comment, that makes sense to take it out and just, you know, take it out from the rest of the opinion as well.
Yeah, and I think that makes sense. And that's the term unambiguously illegal, I think, was something that was raised in some of the public comments. But really the comments were just, you know, addressing the fact that, you know, it wasn't clear what we meant by the term illegal, and that in some circumstances it could be legal. So I think if by just having this footnote at the end of the intro, it's sufficient.
Yeah, and maybe just to, sorry, go ahead. I didn't mean to cut you off.
Go ahead.
You know, one other thought I have, since we're taking out unambiguously, and my initial thought was, hey, let's tie footnote 2 to that term. Maybe we should nonetheless tie that footnote 2 to our use of illegal. And so what I'm thinking, for instance, in footnote 2, is we could add some kind of phrase at the beginning, basically saying, by use of the term illegal, comma, this opinion is not intended to, or we'll have to wordsmith that, but just to be, again, tying when we say illegal, we mean what's in footnote 2 as confining our definition. That would require a little wordsmithing to the first sentence of footnote 2, but I think drawing that connection to what we mean by illegal in this opinion to the footnote would just, I think, add a layer of clarity.
Yeah, I mean, we basically sort of defined it at line 44 and 45, right? Where we're just saying it's illegal at the time the agreement is made and not subject to exception. I mean, we could have some version of that as a part of our description of it, which is, or we've later said that in the jurisdiction, I mean, there was some description later about what we meant by illegal too, but we could tie that into that definition and include what's in footnote 2.
Okay, yeah, fair enough. Just a small point. I don't feel that strongly about it. Just a couple other minor comments. Again, not an English major, so tell me if you think I'm wrong, but it was at line 89, or what was line 89? We have these quotes for knowing, knowingly knows. This is so minor, I'm not even sure why I raised it, but I'm wondering if knowing, when we say knowing here means the lawyer, I don't know if we need quotes for knowing. So just something to think about. Not a big deal. The other comments, I have two more comments, or maybe three. When I read footnote 16, where we, at least the original footnote, it says, for the purposes of this opinion, we assume that the in-house lawyer. What struck me was I wasn't sure if we previously made it clear that it was an in-house lawyer. We talk about how the lawyer works for a large California corporation, but to be honest, I was thinking, well, maybe it's just, because of what I do, outside counsel, and it doesn't really matter. But it just kind of struck me like, oh, I haven't seen that phrase in-house lawyer before. So I'm just wondering if in around line 47, when we want, maybe we just say in-house lawyer works for a large California corporation. Again, it doesn't really matter. It just, I think, makes it a touch more clear that the lawyer we're talking about is in fact in-house, as opposed to just someone working, has a client and therefore working for the large corporation. Again, very minor, but it just kind of stood out to me when I saw the words in-house at footnote 16.
So I'm sorry, Justin, what's your suggested edit?
My
You want to
suggestion
add?
at 47, statement of facts, we would just say in-house lawyer works for.
Got it.
So there's, yeah. I don't feel that strongly about some of those, but just my thoughts. One thing that struck me throughout the opinion is I think we need a little bit more parallelism when we're analyzing what it is we have concern about the lawyer doing. And what I mean by that is we have these phrases about we have words like enforcement, promulgation. So for instance, at what was line 21, it says if the lawyer later assists the client in promulgating or enforcing. But another, and that's good. I think both of those scenarios are relevant to our opinion, and I think they're different. Promulgating versus enforcing, right? The promulgating is just the preparation, drafting, and getting executed this document within a legal provision. But enforcing, in my mind, is different. That's once it's been executed and there's some dispute that arises, and with respect, and then this illegal provision is triggered, and then the lawyer is asked to go in and enforce whatever that illegal provision calls for. And so in my mind, those are two different scenarios, but very relevant to our analysis. And sometimes we talk about just one or the other. And so, I would just say as a matter of parallelism, when we're going through the analysis, we just want to make sure that we've covered both of those. And I'm trying to find an example. Yeah, and this is maybe a bad example, but in the conclusion, for instance, we talk about at 206, the use of the contract provision. So again, maybe not the best example, but it's also about the enforcement component. So I would say just as we're finalizing this, if our analysis is only focusing on promulgation and not enforcement or vice versa, that we make sure that we're talking about both so that we have that kind of parallel approach throughout the opinion, because I think both scenarios are important, and I think we're intending to talk about both throughout. And let me see if I have anything else.
I had a question on that proposed change there. If we add the word in-house at the beginning of the statement of facts, it strikes me that when you apply that to the following scenarios, that's essentially limiting this opinion to just in-house counsel. Wouldn't it be better to maybe modify whatever that was?
Footnote 16?
16 to just say in the case of an in-house lawyer or something like that. Because if we add in-house to the statement of facts, then That's all this opinion would apply to, is in-house lawyers.
I agree with that.
Yeah, so if we just tweak 16 to say, when, you know, some of the effect, like in the case of an in-house lawyer,
Right.
we assume that blah, blah, blah.
Right. So yeah, so then the opinion covers both this, when you have outside counsel, but also addressing this particular concern when you have an in-house lawyer and what they might need to do in terms of terminating representation of their employer.
Yeah, and we have more language on that we need to work through. But yeah, I think that's a good suggestion, Ken, because I think it was intended to include both situations.
Well, I
and I think it's better that way.
One of the comments raised something about that in the past, so.
Yeah.
I got to step away for 1 minute. A plumber just arrived, so.
So anyway, I think that's enough for me. Yeah.
Other folks, thanks, Justin. Other folks? Andrew, while I'm looking at this page, on footnote 19 at the bottom, and you took out unambiguously, I think instead of saying unlawful, we should say illegal. We should just keep with our same language. So are you able to share that footnote 16 that Sarah sort of had revised? Or, I mean, we were talking about it a little bit online, yeah, or off.
Do you want me to place it in the opinion or just look at it in isolation?
I mean, I think you can place it in the opinion, but I wouldn't delete what's there. Yeah, that kind of thing.
So I'm going to revise it based on Ken's comment.
And so this sort of goes to our larger discussion, just to frame this issue about whether we should say more about the question of whether or not this in-house lawyer would have a duty to terminate the representation, which I don't, you know, I'm not sure that we want to weigh on or suggest. I like the second sentence in here. I'm not sure in terms of the first sentence with 1.2 whether the in-house lawyer would really be able to get like their company to agree to inform written consent that they wouldn't have to be involved in it. I mean, I'm not sure that that's very realistic. And then we would suggest, and I know we don't want to suggest that if they didn't get it, they wouldn't need to resign, but I was just sort of thinking about sometimes in an in-house situation, you have lawyers that like, you know, they do certain things, but they hire outside counsel, and it may be a situation where, you know, the lawyer says, I'm not going to be involved in that. And then someone from HR goes off and hires someone else. And, you know, that lawyer, we would say, still has a duty to report that up the ladder because that involves potentially the promulgation of illegal conduct, but they wouldn't necessarily have to quit their job, for example, right? They may not have this duty to litigate it and do all that. So but I think, so the question is whether we want to raise 1.2, but sort of the question is how exactly do we want to frame this? I think it's a larger analysis or discussion, and as some people have weighed in on, it's really not the main focal point of our opinion, but we certainly want to address it in some way, I think, is the consensus. So I'd be interested to know people's thoughts.
And just to clarify, Dina, I agree with you as to the first sentence. And Andrew, I think of the way you modified it actually, I wasn't proposing that we say we assume that the lawyer, I was proposing that we just say, in the case of an in-house lawyer, the lawyer may be able to, so you're assuming it. And I think that was but I tend to agree with Dina's analysis that, there are certain factual situations that we probably don't want to get into about this scenario where I certainly don't want to imply that you need informed consent in this situation in order to exclude that from the scope of the representation, and that absent that, the in-house counsel has to resign. So after reconsidering it based on Dina's input, I agree that maybe it's going a little too far and could be misinterpreted, the first sentence.
So, I mean, the one question is, could we say the first sentence from prior, the footnote, that in the case of an in-house lawyer, that we assume they'd be permitted to terminate that representation, like the first sentence of that, and then the second sentence from here. But that wouldn't really address the 1.2 question, which we may want to say more, or some version of these two things combined would be one idea.
So you want me to replace the new footnote, first sentence of the new footnote with this first sentence?
Well, I don't know. I would like to hear what people think about introducing 1.2.
I think it's appropriate to introduce 1.2 without suggesting that 1.2 provides a complete answer. And that's, I think, what the footnote does. The thing is, we really, if there's just no guidance out there that I know of regarding how you apply limitation of representation in the context of in-house counsel, which is why I think we're thinking it's something for another opinion. But I think the germ of the idea is in 1.2b2. So I think it's appropriate to say see rule 1.2b without really providing a complete explanation or analysis, which I think would probably be pretty long, about how that would work in the real world.
Do others have thoughts here?
Just catching up here and reading the new footnote.
I mean, what if we did something like not to make it overly long, but we can, if we're not going to vote it back out, we can revise it over there. But what if we did something like the first part of that footnote, well, it's now 17, we call it 16, but in the case of an in-house lawyer, we assume that the lawyer would be permitted to terminate his representation of the company, or we're not going to use his, but that lawyer's representation of company with respect to this matter, and that would not impact lawyer's representation of company on the other matters, and then kind of have, that, well, or ethically limit the scope of the representation, take out informed consent, but reference the rule, like some combination of that. And because then this whether they would need to withdraw from, I mean, this is sort of, I think that's an important thing, but we need to sort of have the first part of it needs to make that second sentence connect.
Well, 1.2b talks in terms of whether it's reasonable. Two things, reasonable and informed consent. I don't know if that's appropriate to cite to. I mean, with the second sentence or the last clause of the second sentence kind of goes into some of the factors you look at to determine whether it's reasonable. But maybe there should be a little more discussion around the site, or maybe right after the site to 1.2b, and just cite to the fact that 1.2b says the limitation on scope must be reasonable and must be subject to the informed consent of the client.
I mean, I guess I see the value in putting in 1.2. I just don't want to assume that in all situations, it's not just for the lawyer to continue on in the representation of company. They may be able to just terminate the representation with that matter. I don't think we should concede that that's not a possibility, right? In this situation, that it's not always about limiting the representation, because the scope of the representation may not have included, promulgating or enforcing the provision in the first place. So it's not like they necessarily have to, in all situations, would have to go back and limit the representation, right? There may be circumstances in which they do have to do that, right? So I think it's fair to reference that, but I don't know that we want to assume that that's the way out of this, which is that they have to try to limit it. That may not have been part of the original scope of the representation and duties of that lawyer. We haven't really established those facts enough to make that determination. So I think we're trying to issue spot some things here to consider and then leave it alone. But
doesn't the scenario suggest that, the whole scenario is built around the fact that, in fact, it was in the lawyer's portfolio, and part of the lawyer's charge was to advise HR on this particular provision. I think a reasonable limitation, saying at some point, hey, HR wants to do this, and I think it against my advice, and I don't think I want to work on this particular matter anymore. And will the company agree to that? To me, that's probably reasonable and probably sufficient informed consent. So,
but advising on a matter is different than promulgating and litigating a matter. For those of us to do it, would you like advice and consent? You could be advising someone on a provision, and the enforcement of it, or how they're going to use it, or whether they're going to go out and file a lawsuit to try to, that is beyond the scope of what the representation would say. So oftentimes that representation letter is very limited in that way. I'm giving you advice on this. I'm not going to litigate the matter for you. I'm going to give you an advice on a reasonable interpretation of this or what it is. So I think that's usually something done beforehand. It's not just anything that has to do with this provision whatsoever, because you're giving me advice on it, you're responsible for it. Now you have to go file a lawsuit for me. And if you don't, then, somehow that is part of your original duties and you have to terminate that. That, to me, most people that do that transactional component are not doing the litigation component. But
yet there may be situations involving smaller companies or closely held companies, very small companies, where one lawyer is wearing all the hats. And that's part of the reason why this issue is a bit of a quagmire, because there are many permutations. Not every corporation is a huge corporation with a robust core of lawyers. Sometimes it's one guy, or maybe increasingly in-house counsel stuff is being outsourced to, I don't know how to put this, outside in-house counsel. And I know lawyers who do that work, where they're essentially providing it to many small companies. So there's so many permutations. I don't know what I'm trying to say here, but it's perhaps part of why I don't want to get into a huge discussion about, all the many ways this could happen.
Yeah, I share David's concern. I think this is a very important issue, not just interesting, but one that affects huge portion of the state bar, in-house lawyers. And having this footnote, it's interesting, it's instructive, it's helpful, but I feel like just making our comment and saying, see the two rules, doesn't do justice to the importance of this issue. And my thought would be that we should dig deeper here in terms of authorities and see if there's further analysis we can do. Maybe we need to put some more guardrails to what we're comfortable saying based on that analysis. I would feel a bit remiss if we confine this important issue to a footnote with just a go see two rules. I think this deserves some further research and then discussion before we finalize this opinion.
Well, I'm not really in favor of expanding the analysis on this, and I'm not suggesting that that we shouldn't. Maybe it isn't going to be ready to be voted back out today, but I'm not generally not in favor of expanding the analysis on that. I do want us to not open a bunch of boxes and not answer questions for them, but I don't want to, I mean, I think others have spoken on this, like, that's the tension between, like, is this really the thrust of our opinion? I mean, do we want to, or are we going to have a big analysis on this issue? So I think that's sort of the tension, which is whether we're going to say this is sort of beyond the scope of the opinion, or we're going to try to answer some of these questions, which would lengthen the opinion.
Yeah, I mean, and it may not be that we have to expand it. If we decide to keep it, maybe we don't have to expand it, but maybe if we, upon vetting it further, we come to the conclusion that our citation will be, I don't know, have a little bit more explication to it for the conclusion that we reach. And I just feel like, given how important this is, it's worth the further vetting before we finalize it, and then decide if this should be a separate opinion because it's so important or nuanced, or whether we can feel like this kind of cabined point is sufficient. I personally just don't feel like I have enough personal background on this issue to feel comfortable saying, this is good enough for publication just yet, in terms of just, speaking to this footnote.
Well, we were talking about not using the part highlighted in blue. We were not going to use that first sentence probably, but some revision of that, maybe combining the top footnote, but, and then including the second, but I hadn't quite worked through the best way to state that, I think. Other thoughts about this? Is the consensus that we need to spend a little more time on trying to tighten up the section and was thinking through this before we?
Just one alternate, totally divergent course of action would be that we move this concept into the in-house counsel opinion entirely and don't even reference it here, because every lawyer has to fulfill his or her own obligations, and an in-house lawyer will look to this opinion and then hopefully the other opinion too.
I'm kind of more with Justin on this. I think we kind of have to address it to some extent in here, because I mean, if memory serves me, I know it was in some of the latest comments, and I think it was in some of the earlier comments, this whole question about in-house counsel, and the way the fact pattern is, it's not specific, but it kind of, works for a large corporation. That certainly could include the in-house counsel. So I think we have to address it to some extent. I kind of think, I agree, I think it needs a little bit more work on that issue.
So this isn't going to resolve the divide, but going back to my prior concern about the wishy-washiness of the digest, and here we use the phrase, if HR insists that the lawyer be involved in promulgating, enforcing, lawyer would likely be required. We could either assume that that is affirmative enough and just end the sentence without the footnote, or we could say will be required. And again, assume that that's affirmative enough, remove the footnote and just cite to the mandatory withdrawal provision. We support the reason why mandatory withdrawal would be required here. I'm siding with Dina. I think this is a tough issue, and we're circling around potential nuance where there might not be nuance in the opinion and trying to address it in a footnote. I think it might be fraught with peril, and I just question whether it's necessary.
I mean, the other issue too to consider, and I don't want to rush this out for public comment before we feel as a committee that we're ready to do it and comfortable with it. But it will go out for another day, 60 days of public comment. We'll get more feedback on it and we'll be able to see it again. And moving it over to the next opinion is going to lose some of our members and then it's going to be, I don't know, it may potentially take a lot longer to vote it out. I don't know. That's another concern, but
Yeah, I agree that we don't want to go into too much of an analysis here because it really does depend on the facts. And we don't address those facts in this opinion. But at the same time, I'd like to be able to, reference some rule that an in-house counsel could look at for guidance while still making it clear that, this is outside the scope, given that it depends on particular facts. So I like the idea that, I think, Dina, you recommended kind of combining the first sentence of the original footnote with the second sentence and maybe slightly revising that first sentence. So I do think we should address it to at least that limited extent. But I mean, I'm okay also if we want to, as a subcommittee, conduct a little bit more research. I have not, researched this issue thoroughly, so I don't know if there are particular authorities that we should be citing to here in addition to the rules.
well, we could do that first sentence of footnote 17, and then we could cite to rule 1.682, but then also say, see also rule 1.2b with respect to limiting the scope of representation. I don't know, something just to flag that if you think, and then put that second sentence. I don't know if maybe that's too convoluted.
I understand what you're saying. I think if we're going to go with that, maybe we say at the first sentence, we assume may be able to, permitted to, instead of terminate his representation, maybe we just say decline representation of the company with respect to the matter, because it's not clear that he's already representing, that lawyer's already representing the company on that matter. And then we could say, or ethically limit the scope of lawyer's representation to exclude that matter. And that way it kind of ties in if we are going to include a cite to rule 1.2b.
Yeah, that makes sense to me.
Sorry, Sarah, I missed
So I was
where
saying, so
or ethically limit. What was that language?
Or ethically limit the scope of the lawyer's representation to exclude.
No, so that would be
I'm
right
sorry,
after
where would it
matter.
go? Apologize.
Right after
Oh,
matter.
sorry.
The first matter.
Yeah, right there, yeah.
I guess we could just say this matter. If we're going to keep the second sentence, I don't know that we need, and that it would not impact lawyers' representation of the company on other matters.
Yeah, I agree with you. Take that out. And then you take out the his next to decline, Andrew, please. And then cut and paste down to C rules 1.2b, right, Sarah?
Yeah, I think that's a good idea. And then the rest of this paragraph, or the rest of this footnote, you could just cut and paste the whole thing.
Do you want to bring everything that's in blue up?
Well, not the whole blue, just starting with C rule 1.2b. So not the first sentence. Yeah.
And replace this last sentence? Or
Yeah.
keep it? Okay. Formatting. Okay, I try to make that clean to see if it'd be easier to read.
I mean, I think that's good, actually.
The only wordsmithing I had there is because we got two this matters. When we just say be permitted to decline representation or
Oh, yeah.
limit the scope of the representation of this matter.
Yeah.
Yes.
I think that looks excellent as a good way of limiting the dive without exposing people to bad advice.
And Andrew, you wanted to, scrolling up to where we talk about footnote 17, you wanted to limit, you didn't like, there was some ambiguity with.
Well,
like,
I think I was trying to propose an
I think
alternate
we were
solution,
saying
but
would likely be
okay.
required because we were saying depending on the facts, right? That's what I think.
Of course. No, I'm with you. But here, and I get that. I guess I'm not trying to be difficult about it, but we're framing it, but insists to be involved. I mean, is there any ambiguity the way the sentence is framed? I'm not trying to be obnoxious or annoying about all this, but it just bothers me when we. I don't know if bothers is the right word. I see that and I'm like, well, it's clear, and we should be, when the rules are hard enough, when clear, I think we should be clear.
Well, I think the way
firm conclusion.
The fact in which they wouldn't be required to terminate would be if the lawyer says no. They insist and they say no, I'm going to limit the scope of the representation, or I'm going to decline, and so that's when it would be not required. But
sure.
if the condition of the continued work was that they were going to be involved in it, then I would say that would be it. That's a no-brainer, which I thought we say elsewhere too, that would be mandatory. But
it's cool. Not a big deal.
I guess I think what we need to decide right now is whether we want, if there's some other minor things we can address related to comments that we got, to be in a position to vote this back out for 60 days, or the consensus is that we'd like to, digest these revisions again and look at it. The subcommittee can look at it again over the between periods of time and the next meeting and potentially vote it out next meeting. I'd like to get a sense of what people would like to do with this. I know we're going to be losing David next meeting.
Well, I think there's probably enough to talk about and I'm not sure we're ready to vote it out. So I think we need to consider whether we need more than this footnote as a discussion and maybe some other issues. Seems to me you probably should not vote it out today.
Okay. Do others agree with that? Is that the consensus? Okay. I see some heads nodding. Yes, we agree. So I think that we, for those people whose heads I can see. All right. So, well, that's good. So before we leave the opinion, where it sounds like we're not going to try to vote it out, and but is there any other feedback, particularly from members who will not be with us after this, about revisions or things they would like to see or didn't like to see in this round, or anybody? But okay, I mean, I think it's really close. I think with we can just have some tweaks and just like looking through it for the continuity purposes and some revisions, and it'll be really good. I think it's a lot of work on it, so thank you. All right. Oh yeah, this is the part of the meeting where we get to say our, what did you call it, Andrew? Gratitude and thankfulness and goodbyes. And I feel like we're like this really small group right now.
I know, it's unfortunate we are.
I know.
So I word it as gratitude, respect, and stay in touches.
Respect.
But there's other ways to approach it. Yeah.
No, I like that. Well, if I can say a couple comments, and then I will turn it over to Andrew and Steve or Justin and anyone else that wants to say anything. This is my last meeting as chair, and I am very truly grateful to have served as the chair. I feel like when I was reflecting on being a chair before the symposium, my opening remarks related to that, that gave me a lot of time to reflect on all the great things we've accomplished. So I don't really want to repeat everything that I said there, because I feel like you guys heard a lot of that, but I just feel, for me personally, it's been a professional highlight to be a part of this committee. It's improved the way I look at legal ethics issues, the way I think about them, the way I interact with other people about them. And so it's made me a better lawyer, hopefully a better person as well. But I just feel, I'm just impressed with how much we've accomplished as a committee. And it's hard. This isn't easy stuff. It's exhausting to read some of this, thinking through it. It's not, this is sometimes, most of us do all this for a living a lot, right? It takes up a certain amount of bandwidth and brain power. Then you're like, oh, on my free time, I'm also going to like read really complex and difficult things and think about them. So it's hard. so kudos to all of you guys, and thank you for staying with it. And obviously, so much of what we do successfully requires that dedication and thoughtfulness and, you know, commitment to doing it. And I know we all have a million other things going on, especially during these times, but everyone's made so many contributions to the committee, and it's anyway, for me, it's been great, and I really appreciate it. For staff, for like the entire Office of Professional Confidence, it's, you guys are, as we always say, you're what makes it run, what makes it work. You make us best and better, and I want to thank all of you, but particularly you, Andrew, and Mimi, who hold us together. And, you know, as we've said before, behind the scenes, you don't know how many emails Andrew has to respond to and deal with. And we're obviously not his only committee, nor his only responsibility at the State Bar, but he's always responsive. He's always professional. He always gives us the guidance we need in a timely and thoughtful way. So really appreciate that, Andrew. You're, as everyone says, you're such a easy person to work with, and you add so much to making us terrific. And if Mimi were here, I would say a lot more wonderful things about her, but I'm not going to, because she's not here. So no, just kidding. And so as you said, Andrew, we're losing 4 people of this committee, and we're losing David, and we're losing Adam, and we're losing Amber, and we're losing Steve. And that's a lot. So it's going to feel really strange to be without you all. And, you know, I'm just going to say a couple things about each of you. David, you've been such a great resource for us as a group. You're such a thoughtful person. You like the professional discipline side of things. You're our guru that we go to on that, because not a lot of us know about that world. And it's been so helpful, your professionalism and guidance. And I know that you have been your help with the symposium, all the subcommittees, the prospective client opinion, this opinion that you've helped with, and we always appreciate your feedback, and it's truly valued, and we're going to miss you. And Adam, where's Adam? Adam is one of these people that is not afraid to say what he thinks, no matter what people think. And it's important, because sometimes we get in this like group think of like, okay, it's all good. And you're like, wait a minute, does that make sense? Or I don't agree with that. And it's important. We should have lots of people like that on the committee, but it's important to have those people on the committee. And you've been a part of so many important subcommittees and sub-working groups on all these opinions, the prospective client opinion. I would say to David, I'm sorry that the expert witness opinion didn't get to be seen through on your watch, but so much work went into that. That is such a thorny and complex issue, and I appreciate all your efforts and revisions and trying to incorporate what we all said into all these drafts. And I know it's going to come out, and it's going to be great, and it's going to be really important. So I appreciate all your work on that, and your levity and what you bring to the committee. And Amber, who's not here, Amber has also done a tremendous amount of work on the committee, as you all know. And I always think of like when Amber says something, it always feels like it's always so thoughtful and insightful, because I feel like she just really spends time thinking of what she's going to say and adding to it. And the file retention opinion and what she did with the closed files and the criminal, incorporating that in the rule revision, which is for some of us not as exciting as other topics. I think she did a tremendous job on that. So I really appreciate her for that. And oh wait, finally, last but not least, Steve. I'm just kidding, Steve. I didn't forget about you. I can't even imagine what COBRAC is going to be like without you, because like my entire time on COBRAC, you've been a part of it, and I can't even think about associating this committee without you on it. It's just like a huge hole. As Justin said, we're going to need 3 people to replace Steve. We can't just be like one person, that we bring in. But no, to talk about all the things that you've been instrumental in is just every single opinion that we've published. I mean, the advising cannabis opinion, the prospective client opinion, the impaired attorney and diminished client. Those are all those opinions, which were really, really hard topics, really important topics. I think that we've certainly set the tone under your watch and while you've been on COBRAC of publishing opinions that are have the more in-depth analysis and thoughtfulness than other opinions. And there's a place for all different types of opinions. I'm not saying that all of them should be these big things and that a small opinion isn't important, but really sort of advancing the thought leadership from our committee and heightened that you've done that. And obviously you're an incredible person, thoughtful, great to work with, easy to work with. And you truly seem to like to engage with people on this, which are all the important qualities. And so you're not going to be off the hook by not being involved in the committee. I mean, we're still going to be like having to text you, be like, well, Steve, we got this feedback on this opinion, and what do we say? So, so we're not gonna let you off the hook so easily. But no, you will truly be missed. That being said, I'm really excited for Justin to take the reins, and I'm looking forward to. It's been great to work with him, and I have all the confidence in the world that everything. The committee goes on, right? We get great new people and everyone steps up, and it's just kind of as Andrew knows, he's been on it for how many years have you seen these iterations of the committee? And it's important, all these people stepping up. And I'm really excited about Justin and Sarah stepping into the leadership roles while I coast as an advisor right now. I'm not going to be coasting, right? I'm excited to stay on as an advisor for another year. And I'm excited to have Toby back for another year, because that was one of the things that we were able to accomplish, which is to have her be a part of the committee for one more year, which is tremendous. So anyway, I feel like this is a long, boring speech, but I just want to let you know how much I appreciate all of you. And now I feel like, okay, so I didn't talk about Ken and Brandon, who are the only people left here that I didn't talk about, and you guys are awesome too. But I'm going to see you around, so I don't have to worry too much about that. So there you go.
Well, if
As I could do my mic drop now.
yeah, if I could just say a few words about Dina and our members who are leaving us. It's really hard to know how much has gone on behind the scenes trying to make this committee work remotely for an entire year. And Dina has made it look so easy, and it's not. She's put so much time and effort into making this continue to run like a well-oiled machine. And I've learned so much about leadership and about making that extra commitment from seeing what she's done this last year. And I cannot tell you personally how excited I am that we have an advisor again, and to have you for another year. The brain drain that we were about to encounter in this committee before we were able to have an advisor again was very daunting to think about. And we are so lucky to have you, and thank you for committing to a sixth year on the committee. It's going to be awesome, and having you in leadership with Sarah is going to be. I hope we can continue to be as efficient and thoughtful as we've been under your chairship here. David, I got to say, whenever you start talking and cite a rule and a subsection and a comment, it blows my mind how well you know the rules. But it's not just that, you've brought a level of pragmatism on top of that I feel like a lot of ethics nerds like all of us here don't have. And I've learned so much from seeing you both off the top of your head cite rules and then offer just this coherent, pragmatic thought. It's really inspired me to try to know the rules better so that I too someday can just do that off the top of my head and be as impressive and knowledgeable. That's just, small anecdote of or impression that I've had. And it's been great to have you. I wish that for all of you really to have been able to see you in person, and I hope we can all see each other again live someday. Adam, on that point, I have really enjoyed getting to know you. I'm sorry we didn't get more conferences where we got to hang out. That was fun in San Diego. I thought we'd be doing that every year. Who knew? But hopefully sometime soon. It's been a lot of fun working with you on this expert witness bear of an opinion. So we'll do our best to marshal that, and hopefully you'll still be willing to answer our questions, because just because you're not on the committee doesn't mean you can't help us every now and again. Steve, Dina apparently thought it was okay, and it was, to disclose our personal private conversations about you, which is basically that we're both wondering how we replace you, given that you do the work of 5,000 people on this committee. You've been a stalwart member of this committee, and I have to say, personally, whenever I have the opportunity to work with someone with your experience and gravitas, but also maybe most importantly, your humility and willingness to, interact with someone like myself who doesn't have 30, 40 years of experience in ethics and converse and dialogue. It's so special. And I can't tell you how special that's been for me to have that opportunity to work with you. And it means a great deal. And I've learned so much from hearing how you articulate thoughts and opinions and incorporate other people's views when you know so much about an area of your expertise. And I really appreciate everything that you've done for this committee. And I'm going to miss, it's very strange, the idea that we're not going to have your insight and thoughts at each meeting, because I've grown so used to it over the last 5 years. I just want to thank you very much. And yeah.
I want to say just a couple of things. I've been talking with my wife about this for a few weeks because I'm actually going through a lot of sadness about this. I am so exceptionally fond of the work and, more important, the people. And I just can't say enough good things. But I'm not going to take a lot of time. I just want to do a couple of things. First, I want to adopt by reference everything that Dina said about the work of the committee over the past year, and also about the staff and about all of you. The second thing I want to do is to single out the leadership who are coming up. Justin and Sarah, I'm so excited and happy to have you moving into a leadership role. You're both wise heads with a lot of good judgment, thoughtfulness, kindness, and it's going to be a great time for the committee under your leadership. A word about staff. I've already told Mimi how much I'm going to miss working with her. And Andrew, I've said so much to you in the past, I don't want to gild a lily, but let's just be clear that it is a lily. You're the greatest to work with, and I don't mean by any of this to exclude other people in the Office of Professional Competence. Randy has made really important contributions, Angela, and so forth. I don't want to exclude them, but Andrew, it's been just a pleasure working with you and me. I want to mention one other member of the committee before I turn to Dina for 1 second, and that's Toby. I think that it is really challenging to be a public member on this kind of committee. We are playing inside baseball here in a lot of ways, and Toby has been, I think, extraordinary in her willingness to master the technical details of what we're doing while also holding on to a very well-developed and thoughtful ethical sense in the wider sense, both in terms of personal conduct and the public interest. We are so lucky to have had her, and I just think it's really remarkable that we have a public member like you, and I'm so glad you're going to continue to serve. And finally, Dina, I might tear up here. It has been so great working with you. You, as a vice chair, you were extraordinary. As chair, you've been extraordinary. It has been one of the really good working relationships of my professional life. I've liked it, all of it, and it's not simply a matter of what a good lawyer you are, what a good writer you are, what a prudent and strategic person you are, but just what a good person you are, period, full stop. And it's been a true delight for me. And I think all of us would agree that you've been a marvelous chair. And all of us are so happy that the committee will have the benefit of your work next year. Thank you so much. And thank you all for a great professional experience, really.
I mean,
I'll
I didn't
jump in.
even.
Oh, go ahead. Sorry.
No, I was gonna say, I didn't cry when I dropped my daughter off for college, Steve, and then I mean, I cried later. Anyway, thank you. That was lovely. Sorry. Go ahead, Andrew.
No, I just wanted to quickly say, and I appreciate everyone's comments about staff, although she's not here. The meeting is being recorded. Maybe she'll come back to watch it, but I do want to, it would be a huge oversight for me not to mention Mimi. I enjoy working with Mimi, and I know you all do too. I'm not filling this gap because that there's any sense that no one doesn't acknowledge and understand her importance. But I wish she was here because I know she enjoys working with all of you so much. But I just want to publicly state how hard she works, how quickly she works, how competently she works, as you've seen this week in my inability to get materials out in an efficient manner. We all miss Mimi when she's not here. Not to feel too sad for her. She's in Italy and France this week on a 2-week vacation. Well deserved.
Nice.
So she's doing just fine. But
I cry for a different reason after hearing that, right?
I know that she's sad not to be here. And yeah, I'll leave it at that. I mean, I think I said everything I said at my introductory remarks. I just really want to say thanks for all you say about staff. I'll wish my supervisors were on this meeting at the time those comments were being made, but such is the way the cards are dealt in life. But it's such a pleasure. This is really the highlight of the work I get to do at the State Bar. I do a lot of different things, a lot going on at the State Bar these days, but I hold tight to my responsibilities with the work of this committee because it's a personal joy in terms of the subject matter. I really get motivated and uplifted, much like the rest of you do when you speak so fondly of your work on the committee. I feel the exact same way. It's almost like you're bitten by a bug and you're just, you got it going through your blood at some point. But it's also just a joy to work with people such as yourselves who are similarly invested and interested. It makes the work easy. Every committee year is a little bit different, but on years such as this, where we have invested members who are working really hard to get materials out and get an in-depth, thoughtful, respectful discussions, it's really rewarding. And it's a great exemplar to see in terms of how to comport oneself in other meetings and in other interactions with folks. And so, I'm just blessed that I get to continue on this committee year after year and continue to learn and grow. And I just reap the benefits from all you guys volunteering, because doesn't go without notice that you all are practicing individually and are only here, with the limited extra hours that you have to devote. So I really appreciate that, and really looking forward to working with everyone that's continuing on. Unfortunately, Amber and I guess Amber is the only one who's not here. And I sent her an email, apologize for not being able to say goodbye, but David and Adam and Steve, it's not going to be easy without you guys, but really appreciate all the work you guys have put in. And Steve, it feels like you've been an advisor for 6 years. Right after your first year on the committee, you were given a lot of roles, especially being lead drafter, I think on 2 opinions. I think I phoned you personally to beg you to do it, and you were ready to do it. And you've been a big help to all the work and all that's been accomplished by the committee. And the committee's gone through some changes over the last few years, and you guys have all handled it very professionally and with open arms, and that's been really appreciated from my personal perspective as staff, that although there's been change, there's been a lot of acceptance and working with the organization to fulfill the objectives of the Board of Trustees. So I just want to say a personal thank you all to you all for that. And that's it. Except the stay in touches part also is true. I know many of you professionally work in other groups and organizations, so your paths will cross for different reasons. I still am in contact with and speak to many former members of the committee for a variety of reasons, and I hope and trust that that will be the case for those members that are leaving this year. So please stay in touch, and maybe there'll be another state bar initiative in the future you might be willing to serve upon, and we can work together on that.
Thank you, Andrew.
Yeah, thanks, Andrew, and thanks everybody. Does anyone want to have anything to say else, or we want to move on and talk about another ethics opinion? We'll have to. I'm just kidding.
I'll be brief. I just want to say thank you for a great professional experience, really the greatest professional experience of my career. I want to thank Andrew and the staff at the State Bar. I've been involved. I've been an intimate observer of the State Bar for over 32 years. And I will say that Andrew, Mimi, Randy, everybody in the Office of Competence, you're the best of the best. And I've seen quite a spectrum of people at the State Bar. You guys are incredible. And just a big thank you. And lastly, thank you for all the kind words. I'm moving into semi-retirement next year, but as you said, Andrew, once you get bitten, you can't really. It's like the mafia. There's only one real way to leave legal ethics. So, even though I may ironically have more time to contribute to various projects after I semi-retire next year, so you probably haven't heard the last from me. So, a fair warning. Thank you so much.
I just want to say briefly, I mean, I agree with everything you guys have all been saying. Joining this committee is kind of reminded me when I joined the FEARB committee. I thought I knew what I was talking about when I first joined and realized, uh-oh, these people are great. And same thing here, you know, once I joined, I thought I knew ethics, and seeing all you guys and the breadth of knowledge and how you analyze things, it's been an experience in learning and watching how you guys worked, and I'm going to miss you.
Yeah, very quickly. Look, this has been, I can't tell you all how many times I have thought back to a conversation we've had during one of these meetings that has immediately helped me with one of my clients. Oh, I remember when Sarah said this or Brandon said that, and it immediately helps me figure out where to go or how to analyze something. This has been the most professionally rewarding thing that I think I've done. And I came here within 3 months of leaving firm life and starting my own firm. To leadership, and I'm going to include Andrew in there. I don't know how, I mean, Dina, Justin, Steve, Amy, and Drew before Andrew, I don't know how you guys all know such intimate detail about every single opinion. I have trouble doing it with the 3 that I'm a committee member on. And you guys have a grasp, and Sarah too, who is coming in next year, have a grasp of these opinions that is amazing. And you can tell how much time and work is done. The only other thing, if Mimi were here, I would thank her for putting up with my monthly 3 hours before something is due email that says, I'm really sorry, Mimi, I'll get it to you by 5. It'll be there by tomorrow, or whatever it does. And I know I'm not the only one that does that. And she is very gracious and always says, no problem, thanks. And I can tell she's just gnashing her teeth at the delay that we all give her. So a very appreciative thank you to her. And I will miss being on this. And I hope you guys are all in person soon for your next year's meetings.
One quick selfish note for those leaving and those staying. You know, I harped on this going into the applications process this year, and we had a really great, robust set of candidates. And even though you leave the work of the committee, I know many of you, including David, who says he'll only be doing it part-time, but maybe it'll be 3/4 time, will be continuing to practice. And to the extent you see others who have a knack for this area of law, or are impressed by, please continue to consider those folks as potential candidates and encourage them to apply. It's really your experience here really helps inform who would be the best candidate. It's not just those who know the law top to bottom, but have the time and the writing skill and the ability to turn out work product, as Adam's noting, and as well as, is generally has good congeniality and works well in group settings. I think some of our best applicants come from recommendations of others who have served on the committee. So I just encourage you all to please keep eyes and ears open as you go forth without us, that you can still contribute and help the work of the committee by encouraging competent and strong folks that will lend a helpful hand to the work of the committee to encourage them to apply.
All right, well, that's great. That was nice. I felt like we were almost in person, sort of together, having, I don't know, a real conversation about something. Someday, maybe. All right, why don't we turn to, because I don't want to give Adam short shrift on this opinion. And why don't we turn to our discussion of the lawyer as an expert witness. I just took the wrong opinion. There we go. There was, well, why don't, Adam, I'm just going to turn it over for you to describe changes that were made. I know some other people has shot at some revisions, and there's some reworking, and I think what I'd like to hear from is, just sort of like, what are the changes, what you think work, what we think is like a path forward, just to kind of get feedback on those tensions from the people that are, I know Steve weighed in on some issues. I think Sarah's looked at it, but particularly with Sarah and Adam who are leaving, Adam and Steve who are leaving, that, what is the takeaway that we want to make sure that we capture here of things and revisions or issues that we should talk through?
Sure. So I can start and tell you a couple things that I was working on when speaking of Steve and his incredible ability to keep at this. Steve, and then to Sarah and I, rewrote or moved around and did a lot of work on this one. So I'm going to start off with some of the things I had done before. I have some comments on things Steve did, but we were unfortunately not able to have a subcommittee meeting before today. So I would like to hear from Steve. I think it would be beneficial for the group to hear from Steve first on what he did, what he did, and then I can provide the comments I see from there. I agree with a lot of it. There were a couple things that I had either questions of or had reasons that I hadn't done it that way, but I didn't want to cut things. It's already tough enough to read with a lot of the back and forth, so I didn't want to cut things out. I thought it was best to leave in more and give comments on where I saw it going, since it doesn't appear this is going out this time. So, look, my biggest comment, and I'm looking at the wrong meeting material right now. I'm sorry, I had a computer issue earlier and had to shut down. So maybe if I download the correct one. The biggest comment I have had and thing that I have been trying to fix, and apparently still am not great at, is the difference between scenario 2 and 3, or 3 and 4, and specifically on 4, what I'm trying to get at. And so I hope that I have fixed it by just adding a couple separate words, and that's on 76 to 80. The point of scenario 4 is that the law firm represents a company in one case, and the expert has been asked to serve as a testifying expert on behalf of the other party in that case in a completely different matter that has nothing to do with the litigation that law firm is a part of. And the point of that is, when I was writing paragraph or section, the scenario C, I wanted to bring in and quickly point out the 1.7 C1 rules about written disclosure. And so that is how and why I have put that in there. And I hope that with this rewrite, because I know Sarah has had questions on this for me before, and I hope and think that I have fixed why that is in there and what it is. Frankly, I don't think it's incredibly crucial to the opinion, and it's a fairly simple issue. But it took a total of 3 paragraphs with writing scenario 4 and then adding 2 small paragraphs at the end of the opinion to point out that there is this 1.7 C1 provision and what it requires. And so that's why it's there. And I hope that I have fixed it so that it is, company versus defendant. Expert is asked to serve as a testifying expert for defendant in a different litigation. Defendant is, going against plaintiff number 4 or whatever you want to call it, that has nothing to do with the law firm's representation. So that is one issue I'm trying to fix. The other one that I was working on my rewrite when I got much more extensive comments from Steve that I will let him go to. And actually, Steve had cut out some of this stuff, but I put it back in because there were comments from at least 2 or 3 committee members about this. And I do think it's important to include, and that is in scenario 3, and it's down around line, where am I? Sorry. There's so many different versions of this one. Might have been cut out. So it is the when confidentiality and privilege is lost, and it's the analysis of shadow. And it is upon designation, and the reason that I think is important to keep in, and you know what, I put it into a footnote. It's the footnote on the bottom of page 12, footnote 11. And I think it is important to keep in because I think it raises the issue of when expert has continuing obligations to a to another person in the case, such that 1.7b comes into play. And so I think it is important to put in there. So I had a number of comments to clarify what is now written in footnote 11 about when an expert is designated, the privilege is lost. I tried to, and I know we've had many discussions over the last several months about the difference in the privilege and confidentiality. So I tried to address that, but I think it is important if expert still owes duties of confidentiality through common law, through agency, or whatever it may be, that expert may need to be a disclosure to the client in that matter under 1.7b. And so those are the things that I had tried to clarify based upon comments from the committee. Steve, like I said, I talked to Steve before, but Steve moved a number of things around in his rewrite. And I have some comments that I would like to add in on a lot of that. But I think it would make more sense to allow Steve to kind of say what he was doing with it. And I'm sorry, Steve, for putting you on the spot for that one.
Not a bit, not a bit. I think it's those of us who undertook to revise this, who owe you an apology for not getting it to you fast enough.
Well, thank you, but that's not necessary, and it's the other way. I appreciate that, though.
We could have had a fuller discussion in the subcommittee beforehand, and I think that the timing just got away from us all. And I think we all owe you an apology for that. My main goal, as I got into this, I was kind of stunned at the end to realize how much reorganizing I had done. I think it is and a little embarrassed, but let me run through what the thinking is in the changes that I proposed. And Sarah may have some other comments, because some of what is things that.
And Sarah, I did not mean to not say that you put a ton of work on this either.
Sarah made a lot of good changes to what I had done, I felt, and but let me try to suggest what I was trying to do. So the first thing was to sort of take a position to infuse the discussion of whether you're representing someone when you're an expert witness with a bit more meat, and in particular to tie that is recognizing that we can't opine on the practice of law. To talk a little bit about how expert witnessing might be viewed in the framework of law-related businesses, without actually taking a position on whether it's a law-related business. And so the way that we ended up framing that, and I think this is a helpful way for practitioners, is that if they put in their retention letter, their expert retention letter, that they're not representing somebody and that they're not forming an attorney-client relationship, right? That ought to, under California law, that's a true safe harbor. We don't have to take all the hard stuff on that way, but we can instead just focus on what really we can, in a way, channel people to a really clearly correct way of behaving with our discussion. And that was, I think, my first thought here, rather than trying to mess around with what constitutes the practice of law or what constitutes a law-related business, in essence, to get to the bottom line a little more cleanly. The second thing was to change the discussion of law-related businesses a little bit, and I did that originally simply just for accuracy and completeness. That is to say that you can be law-related in two ways. One is fiduciary, right? And that's where we got into so much trouble with the Office of Trial Counsel, was by trying to soft pedal the fiduciary part in the 16003, the opinion that didn't happen. And the second is the idea that it appears to be the practice of law to a layman, or might be thought to be. And having put that armature on it and then explaining why it didn't apply, it suddenly occurred to me that the American Airlines case, first of all, was relevant to the whole opinion, that it didn't belong at the back of the opinion, right? It's really a question about when is being a witness, right? When can it be viewed as a form of representation? And then looking at it that way, it seemed to me that the best way to think about it was that that the lawyer had assumed a fiduciary relationship, and that under well-settled law, if you assume a fiduciary relationship, you're subject to conflict of interest rules. And that was probably a better way to think about it than trying to distinguish on the basis of changes in language in the rule. Because in fact, it's probably true today, probably still good law today, right? That if you're a fiduciary in a non-disclaiming situation, right? As a lawyer, you better watch out. You're probably subject to a professional conflict of interest rules. Practicing lawyer acting as a fiduciary. That's at least the reading of the case law that I come up with. And so this becomes a way of distinguishing the American Airlines case that that leads to a powerful and durable conclusion, given the way we framed the point about disclaiming, the lawyer having disclaimed. That was at least the argument, the reason for doing it that way. I think the other major change is simply to look then at the, in the discussion of the scenarios, the major changes with respect to scenario number 1, the former representation scenario. And the goal was simply to recognize that misuse of confidential information doesn't exhaust the lawyer's obligations, right? That in fact, there's also the Wachumna obligation, which several members of this committee have taught me about over the years, starting with Brandon's partner, Suzanne. You know, the underlying idea that you have 2 sets of obligations. One is not to use confidential information adversely to your former client, no matter what the setting, but you also have an obligation, no matter what the setting, to not undermine the prior work that you did for your client. And so it felt important to me to recognize the full breadth of the obligations that the lawyer was facing there, and then to show that they weren't engaged, right, on this analysis, right? And then I guess the last point would be there's an expanding a little bit the idea about continuing obligations in scenario 2, about continuing obligations that don't stem from the representation, right? And I think that that's a really important thing to flag, because in my experience, expert retention agreements frequently have contractual provisions that severely limit what the expert can say or do outside of the context of the courtroom in which they're going to be appearing. So that the fact that you have testified, right, which we can talk about how to treat that footnote I have some concerns with that language, although I recognize the correctness of the principle you describe, Adam. But even if you have testified, it seems to me you may well have obligations that continue to bind you with respect to things that you, for example, learned that you weren't cross-examined on, wholly apart from the fact that you might have other contractual kinds of obligations, contractually imposed loyalty obligations that might also apply. I think that captures the main stuff that I was aiming for. Sarah, do you want to talk about what else you saw?
Sure. And I'll start with just, I don't think I made a clear edit to this, but Adam raised this point earlier. I was just confused the way it was drafted between scenarios 3 and scenario 4. And Adam, just to clarify, I think you were saying that in scenario 4, it is the same case, but the expert is testifying on an unrelated issue. Is that?
No, so this is why my writing is poor, but it needs to be clarified, but it is supposed to be a completely different case.
Okay.
You know, in company versus defendant in California, law firm represents company. In defendant versus Widget Co. in Colorado, expert has been asked to testify on behalf of defendant as a testifying expert. In other words, nothing to do with it, completely different case, not in any way related.
Okay.
So that is the point that I'm trying, or the scenario that I'm trying to paint.
Okay. And I don't have the big one scenario. Could you scroll down, Andrew, to just scenario 4? I just want to see how it is described currently. Or is it up high? Oh no, there it is. Is this where we?
I think you're looking for the actual fact.
Actual scenario.
Yeah, just the fact pattern. I just want to make, because I had to keep on going back and forth, and I was struggling to understand the difference between 3 and 4. So on behalf of the party opposing company in a separate, unrelated matter. Okay. Okay, well, I think adding separate here, as you did, maybe that does clarify it. And down below, I think it was unclear as well, but maybe it's been clarified. But that was my one comment, and it looks like you've incorporated that to some extent. I'm sorry, I didn't see what you did to the end. The other issue that I think I expanded on the point that Steve already made in terms of adding the disclaimer. I don't think the disclaimer alone is sufficient, so I just added language to make sure that the expert kind of acted in accordance with the disclaimer and didn't actually provide attorney-client legal services, that the role was limited to an expert role. And I just added language to clarify that throughout. I didn't have a lot of substantive edits. A lot of them were just clarifying type edits that I don't think we need to go over. And I think, I'm looking at to see what else I did. I guess the one other thing, maybe in scenario 2, I think it's around page 10 of the discussion. If you can scroll down, I can explain. And I don't know if, okay. So we're discussing 1.9. Yeah, so and Adam, I don't know if you had a chance to evaluate this. So it's around line 263. The sentence begins, the lawyer has such information and the competence performance of his role as an expert foreseeably requires use or disclosure, the lawyer's testimony would violate 1.9c. I just added to the extent any confidential information were used or disclosed, because I think 1.9c, as I read it, requires a use or disclosure, not just the risk of the use or disclosure. So I wanted to flag that issue and the change I had made for discussion. But I wasn't sure if you had a chance to consider that yet, so I'll pause there.
So I agree with the 1.9 use or disclosure. You had one other comment on there that I was unable to incorporate, and I think it is very important to discuss.
Okay.
But I couldn't incorporate it because I wanted Steve's stuff to be in there and not to change or delete out some of the stuff Steve put in. So Steve, first off, thank you for going through that for me. So I want to preface this by saying everything Steve wrote in here, I believe, is 100% accurate and correct on the law and frankly, useful and helpful. But, and my point on the but is, I have tried for the last year to not discuss what is and what is not the practice of law, and to stay away from that opinion that we had years ago that almost went out about fiduciaries and law-related services. And I have come to the conclusion that I don't think it can be done without talking about what is and isn't the practice of law. And so my thought process on this entire first section that starts at line 80, well, I'm looking at the wrong one, but that starts at line 82. So all of section A of this discussion. I like the idea of a disclaimer. I think that scenario 1 should have the expert doing a disclaimer that says, I'm not your lawyer and I'm only being an opinion testifier. And I think we should just say, for purposes of this opinion, we are not talking about consulting experts. There is a disclaimer. We are assuming for the purpose of this opinion that with the disclaimer, the expert is not within the practice of law, and this opinion addresses conflicts. And then I think we say, because other opinions can discuss what is and is not the practice of law. And the ABA opinion that we cite in here, 994, whatever number it is, does discuss, and it goes through the analysis of testifying experts and consulting and comes to the conclusion that consulting is the practice of law and testifying is not. The DC opinion does the same. And I think that we should, for purposes of this opinion, leave it at that. And I realize that it's not the most helpful for practitioners who are doing both of this. And look, I had a call, I think I said 20 minutes ago that our discussions within here has helped me in my professional life. I have talked to somebody about consulting versus testifying and your duties as a consultant lawyer within the last week. But I think that while helpful, it seems to be difficult to impossible to discuss the difference between consulting and testifying and law-related services without getting into what is the practice of law. And I don't know how we do it since we don't do that. So my thought on this first section, the more I've done it, would be to just cut out 90% of it and move on. I think it's all right. I think it's helpful. And if we could opine on the practice of law, I would leave it all in. But I don't know how we do this. And that was one of the comments Sarah has, as we start off on this opinion in this section on around like line 85, saying we don't opine on the practice of law. And then we spend 2 pages opining on the practice of law. And I don't know that we can just say, we don't do it and then have that be enough. So that is my thought process on that area.
So
it also
Aaron,
makes it shorter, which I think our incoming president is a big fan of. Brevity of opinions. And I can tell you, I had a conversation with someone the other day about COPRAC opinions and them being books. So to the extent that this gets in the single digits, I think people would appreciate it. Other than that, Steve, you made a comment about the ongoing obligations, even if somebody has testified just now, or even if they've been disclosed, even if they've testified. And I agree with that. And I think that would be a good point to make. I think that there is a, let me find the rule. I think that there would be a 1.c disclosure for a relationship, a business, financial, professional, or personal relationship with a responsibility to a party or witness, regardless of whether or not, not per se, if somebody has been designated. I think that's a further analysis, but I think prior to designation, I think it's definitely there. And Steve, I think you're right that I should not be limited within the footnote I wrote such that if designated, then no further duties, and should probably be even further and said, now this is a factual scenario, which depends on contract or what has been disclosed. But I think that relationship is something that should be considered moving forward. I look, if like I said, with the first one, if there is an ability to keep it all in, it is helpful, it is good, it is useful, and it is a proper statement of California law. I hope if the committee wants to keep it in, I hope you guys are better at it than I was at figuring out how to pass the muster of what we do.
well, Adam, I hear what you're saying, and I think at the end of the day, we're going to have to take some serious advice from Andrew and Randy about whether we're crossing the line here. I want to take that advice. It's framed as an assumption, right?
It is.
So I take it that and unless we can so assume, right, we can't get to any of this, right? we can't have any, this opinion is useless unless we can, because without that assumption, it doesn't have any legs.
I definitely think we can assume. I don't think there's any problem with assuming. I just think the rest of that section analyzes.
Right, but I'm trying to be more concrete now. Do you mean the rest of that paragraph?
No, I mean the bulk of the section.
So we can't talk about whether something is law related?
I don't know. We have
In the past.
We have.
I think we should include that law-related stuff in there. I see what you're saying, Adam. I mean, I think my feedback is like, I think that some of it could be trimmed a little bit, but when we basically in section A, I think we could, when you scroll down, I did the comments on the clean version, so I'm sorry. I was thinking when we start with the question, I don't know. I'm sorry, because I'm on the clean version. So right before we get to American Airlines, can you scroll down?
That's it, yeah.
Yeah, so I feel like, sorry, scroll up now, you have the question. So that, I feel like the parts before, this part with the question, I feel like that could be taken out because it's sort of duplicative. I think reference to ABA opinion could be inserted as a footnote to the first sentence on the beginning of it's a closer question. And then I do have, I struggle with including that American Airlines stuff in there right where it is. Your explanation of it, Steve, makes, and reading of it, I'm like, oh, I totally see exactly what you were going for. I just wonder if this whole American Airlines thing needs to be in like a footnote somewhere or just sort of to downplay because it seems to be different. I mean, I understand the distinction between the fiduciary duty agency relationship and not, and how being an expert is one way to factually distinguish this case. I just don't know if, I don't know if it's sort of too much to go there, and if we can sort of condense that whole discussion and say like, you know, into a smaller discussion somewhere. And I don't know whether it should go back in scenario one or not. But I think the law related business question, it's important to say it's a closed question, and we can footnote the ABA and say they decided, you know, they considered it, and the footnote can relate to what the ABA opinion says. But the whole basis of, in my opinion, of making these disclosures in the expert agreement is that you're sort of following the general guidance of a 5.7 and making these disclosures, which are really important. So I think the fact that that's part of the analysis about why we do those things is because we don't want that confusion about the fact that you're not practicing law. So I think that that's an important thing to, at the very least, identify. So that's my view, is that discussion made it stronger. I mean, we could, you know, make little revisions here or there, but I think, you know, I think it's an important part of the opinion. That's setting the stage for the disclosures.
So American Airlines has been, that discussion has been moved around so many times, I can't even remember where it started. I think it started in this subsection A of the difference between consulting and testifying. And then I think it moved to scenario 3 to discuss a contrast with Commonwealth. And then, yeah, so it did. It started in the subsection A, then it got moved into 3 as a contrast with Commonwealth, and now is back in subsection A. And it is an important discussion. And I think it's the closest we have in California to any analysis of this issue. So I think it clearly needs to be discussed. I mean, I think the opinion started out because of American Airlines.
Right, but what about in scenario 1 where it's more factually similar, where you were like, you know, lawyer than expert, and American Airlines, it's lawyer than, you know. American
Airlines is lawyer than expert, so it would fit within scenario 1. Well, it's lawyer than witness, but yes.
Yeah, but and making that distinction, like, you know, which has been done about why this isn't exactly the same and why we shouldn't look to that to determine whether or not there's a conflict with respect to, you know, this other relationship. Yeah.
It may have been within 1 at some point too. It's a very important discussion that needs to be analyzed. It just doesn't have a great home right now in the opinion.
Right.
Yeah, I see that.
The pitch that I would make for keeping it where it is that all of our scenarios concern expert witnesses who have given the kinds of disclosures that we conclude under a Rule 5.7 analysis, or under a or under the 99-154 analysis, which is the opinion I think Kevin wrote years ago. That's the issue of whether expert witnessing is the practice of law is common to all four hypotheticals. So it makes sense to do it early. It could be in scenario one, wouldn't matter that much. You could do it in either place. On the question of how much we should cut from the earlier part of the discussion, I don't think we could have it could be very simple. We need something that says we assume it's not the practice of law. We need something to say it's a closer question whether it's a law-related service. That the ABA had a hard time deciding that, right? But we can then say, but assuming it's a law-related service, disclosures will do it, right? At least provided you don't try to cheat and provide other stuff. That could be very short. That could be a paragraph, if you want it to be. But I take it we need all those pieces, Adam, right?
Yeah,
And so I think that then whoever is going to revise substantively can decide how much of this to trim and how much for example, I could imagine putting the footnote about the reasons we think that our assumption is reasonable. I could imagine Andrew and Randy telling us that all that discussion about why the assumptions are reasonable should come out. I can also see it going into a footnote and being softened, so we aren't really sort of making the argument that it's not the practice of law, but just showing that we just, in a sense, making sure that OCTC doesn't come over and say, you've just blurred the line in a way that really disturbs us the way they did on 16003.
I suppose where I come out on it, and I get all that, where I come out on it is we eliminate dicta and we write into this opinion. So it doesn't necessarily give, it doesn't answer every question about expert witnesses, which is a negative, but we do the proper disclosure and we do expert only testifying as a fact, as an opinion, a fact opinion witness. And we footnote or discuss within a paragraph ABA 97 and DC 337 and say, we're not doing any of that. And here are the issues when it is only fact experts. That would be where I come out on. I mean, look, we can, I just don't know whether, it depends where what we want the opinion to opine on, right? I mean, we can write whatever scenario we want. We can write anything out of it. We could eliminate fact scenarios. I think we can eliminate that issue by having the proper disclosures and not discussing them all. So that is where I've come out on it. But I won't be finishing it and it's all in there still. But that would be my ultimate thought on it, is to narrow the issue and really make it a 1.7, 1.9 opinion.
Let me say that I don't object. I don't think my only concern is that what we say be right. I don't think there's any requirement that everything that we say in the front part of the opinion be said. I do think it's important to deal with American Airlines.
Yeah.
And I think that the ground on which the distinction of American Airlines has been placed here is sounder than the one we'd been relying upon before. But I think that the right thing to do is to, I would say, no, I think it's totally it's in part a judgment call to be reviewed with Andrew on the practice of law issue, and it's in part just a judgment about how useful the other discussion is or how much long it makes the decision, the opinion. But I literally think you could cut this section back if you wanted to 4 or 5 sentences, not the American Airlines part, but the rest of it could probably be written in one long paragraph.
I agree with that. There was one issue in the American airline discussion, and Sarah raised it, so I'm going to go back and look at the Word draft I have because it has comments on it.
Yeah, I could tell you that, Adam, because I was just looking at that, trying to remember, going back to my old draft, and I have it handy. It was, and I did not, it might be in the American Airlines case, but I didn't see. And I think the language that I had a question about is, we're distinguishing the American Airlines case in part on the fact that there was no disclaimer in that case that was attempted or accepted. So the court was correct in treating the witness.
I thought that had come out. I thought you took that out, Sarah. I
I
apologize.
think I took that out because I searched for it, Sarah. I couldn't find it either. So I thought I deleted it, but I wanted to point that out.
Okay, so that maybe that's already out then. Okay.
I assumed that had come out, and I understand why you took that out. And I think
Okay.
Okay, then we've adjusted that one. Awesome.
I think that's the only comment I had about American Airlines. I thought the other grounds for distinguishing it made sense. I'm in favor of Adam, what you propose in terms of shortening and narrowing the discussion on the practice of law and law-related services. I do think the opinion is long and complex already, and if we're saying we're not opining on something and then going to a detailed analysis of what's considered, whether it's reasonable or assumption, I feel that we actually are opining on it. But I do think it would be helpful to put some of the information in a footnote still.
I think it's a judgment call, Sarah. My guess is you're going to do the next revision. And
I know. I think that's
all right, Sarah. Great. Sarah's volunteered for that.
And I know you're going to make the right choices. I want to stress again that my only goal here is that the analysis be correct. How detailed the analysis is not that important, it seems to me.
Got it.
I have 2 questions that came up from the revisions, and I don't know. I wanted to ask them. I don't know where this came from, and I just wanted to get feedback on it so that, because I think it's either Steve. I think it's Steve or Adam, or I don't know. But before we lose you guys, Andrew, could you? Oh, I didn't look at the red line version. I was going to say it's in scenario 2. Let me see.
Give me a phrase and I'll do a word search. Like 3 words for the sentence starts.
Yeah, acting adversely too. That's a bad one because that's going to be everywhere. I just sometimes have a hard time tracking the.
Where is it
red
on
line
the clean version?
On the clean version, it's 248. I think it's at under 320. Is my first question. Okay, yeah, this expert may, however. So I'm going to ask both my questions and I'll take it offline. So my question related to this is, if I understand this correctly, we're describing duties and obligations that the expert might have to the party that he testified on behalf of that are beyond not just duties of confidentiality, but acting adversely. There was, I think, a suggestion that they may have duties to not contractual duties to not act adversely to that retaining party. And I didn't really understand that. And whether we felt that was something that's commonly in expert retention agreements, or it just, I understand the duties of confidentiality typically are, but that was confusing to me, that there would be these contractual duties to not ever, to testify anyway. And if that's the case, then maybe we want to be a little bit more direct about it. The second question I have and this is to both of you, I think, just relates to, we've talked about the fact that this expert, that the conflicts, part of the analysis from the expert's contractual obligations in the prior work are personal to the expert, right? And so that and then the questions about whether they would be imputed because they're personal conflicts under that exception. But it sort of occurs to me, I mean, I think the analysis is it's a personal interest conflict because, they have the contractual duties of confidentiality, and that may result in material limitations to the other, to the lawyers. But I think we need to clarify with that when the lawyer, what is the apparatus in which the lawyer is acting as expert within the construct of the law firm? We're sort of assuming that the lawyer is in a bubble by themselves writing an expert opinion. And I think we need to clarify, at least factually, for some of this analysis, that this expert is probably relying on staff, maybe relying on a junior attorney to write and research this expert opinion. And so that the duties of confidentiality may not just be personal to that lawyer, but may extend maybe to a larger team, or to express in the fact that that's not the case, right? But if the personal interest conflict is based on that expert's prior work and duties of confidentiality, it strikes me that duties of confidentiality could apply to others at the firm that are not just that expert lawyer, because they might have helped with that opinion in some way. And so I don't know if that makes sense what I just said, but it was occurring to me when I was reading it. So
both those points strike me as helpful. My own, I think that I don't know. My experience with these contractual provisions, I think you're right that the language we use about contractual provisions is a little bit imprecise. I do think that I've seen contractual provisions in expert retainer agreements that forbid you from testifying against the company, right? But that obligation is not typically, and as I understand it, one that is continuing. It's during the course of your engagement as an expert. So it might not create a continuing obligation. Whether we want to clarify that in the facts or what have you, is an open question for me. On the other one, I think I'm inclined to think you're right, and I would be inclined, the approach I'd be inclined to take, just to simplify, is to assume that the lawyer did his own work, his or her own work. And so we don't have to deal with the question of contractual obligations that run more deeply into the firm. But that could be wrong.
yeah, I think the second part makes sense to assume that but I think we need to say something about they did their own work, and that the access to those files was limited just to that expert working on the matters, or something that we would need to clarify that.
I think that's huge. I mean, I'm just thinking about how, I work at a larger firm. We have however many lawyers. When somebody wants to do expert work, and this is true at most mid-sized large law firms, you have to bring it in. You got to do your conflicts check. You're saving your stuff to the same system as clients who are getting work performed, where the lawyers are acting as lawyers. The reality is they're using the same legal assistance and tech support and all of that. Everything except, we would say, right, it's not necessarily practicing law in the context of preparing the expert opinion, but in practical terms, that lawyer is working in the same office, using the same systems, working with all the legal assistants. And so narrowing the facts to avoid getting into all those complexities and nuances, I think, is really important. And that's a great insight, in terms of how we revise this to avoid stepping into that.
Does anyone else? Sorry, go ahead.
No, I was just, Do you have suggested language on how to incorporate your comment on that you just made?
I'll think about it. We can maybe think about it in terms of the facts scenario, just
Okay.
adding it to the facts that we assume that, or be a footnote to a fact that would assume that they're working on their own, or that the firm had, they had limited access. Because I mean, that's basically how a lot of firms are managing conflicts and other work, right? Is just limiting access and controlled access. So I think, with screens and stuff like that, I mean, it's permitted, you can do that, but we don't want to suggest, because I do think what Justin's describing is accurate, that a lot of firms don't do that, and you just bring it into the firm and it's part of the whole system, and then it's really like the water cooler. So I'll think about that, how to incorporate that. I just wanted to raise that because I was like, what, I thought about it, and it struck me as needing to clarify. Yeah.
There was an initial, at one point in time, comment 2 of 110 was discussing screens and trying to analyze an expert as a non-lawyer within the firm. Because comment 2 to 110 requires screenings for paralegals, assistants, and whatnot. I actually thought the 110A1 sections had been taken out in favor of 1.7B1, which is the disclosures required when there's a professional or personal relationship from another lawyer within the firm. But those are the 2 sections that I think would be relevant to look into and keep. I think if you're going to talk about 110A1, then comment 2 becomes relevant. And if you want to take the position that expert is not practicing law and therefore there's no issue with 110 to begin with, then you can go to 1.7B1 or B1, sorry. I'm sorry, C1, with regard to another lawyer at the firm having the professional or personal relationship. I think they end up getting you to the same result. I think a screen would be appropriate. I just don't have a rule basis to say a screen would be appropriate.
Yeah, I wasn't trying to suggest a screen in that way, just with respect to my comments, but to suggest that that person hadn't shared the information, so that it could be considered more of a personal interest conflict, right? But anyway, as opposed to one that could be imputed to others. But we can continue to think through that issue. Does anyone have any comments that they want to make about the revisions to this, feedback about it, or also anything that Steve or Adam might want to add about it would be helpful to Sarah and others who are going to be helping her revise it? Okay, hearing nothing. I think we are going to pass on discussing new opinions today. I just messaged Justin about this. I think we're too small and a lot of us aren't going to be here next time. And I think we're all tired on a Friday. So I think that, Andrew, if you could take a note, maybe we'll put that over for new opinions for the next meeting in October with the new committee members. So this will be the end of the meeting today. I think we'll end a little early for our last meeting, which is a nice treat, right? So
last decision of your professional career, of your chair career, the brilliant one, right? You
yeah, exactly. Right, everyone will be like, she was so great, she let us out early on a Friday. Yeah. Okay, so yeah, well, for those of us that will be here, next meeting, we'll pick up on some of these revisions and hopefully get more committee members involved in some of these drafts as we restaff and reconfigure these committees or subcommittees or working groups is what we call them, I think. And for those of you that will not be joining us at our next meeting, see ya. We'll see you around. Don't be strangers. We're only an email away. We'll have to do a Zoom happy hour or something, Kovac reunion, all that with a bunch of fun stuff sometimes, right?
Well, if you
Something
can
like
ever
that.
get
That sounds
to an
great.
in-person symposium, we can all.
Yeah,
For dinner.
that would be amazing. Someday, I think that will happen.
Right.
Yeah, thank you, everyone. I
Hoping
really
to go to one in
for a
April.
meeting.
Thanks, everybody.
Bye, guys. Thank you very much.
Very much.
Bye.
Bye-bye.
Bye.